Well, I beg to mention item number 15. I will be allowed to withdraw this petition, Malad. With the liberty to file a fresh.
50.
15.
Mr. M.R. Odhikari, Land Council for the petition, has submitted that the petitioner wants to withdraw the petition with the liberty to filing with liberty. In view of the above submission made by Mr. Odhikari, Land Council for the petitioner, the petition stands dismissed as withdrawn with the liberty as paid for.
How are you?
May I please, Your Lordship? I paid for list, Your Lordship, I paid for withdraw the item number 39. This petitioner has received his personal belongings, 39.
39.
30.
Yes.
Allow me to withdraw this petition. He has received his personal belongings, sir.
Okay. Mr. S. Islam, Land Council for the petitioner, has submitted on instruction that the petitioner wants to withdraw the petition. Who are there? Mr. S. Borua, Land Engineer Advocate Assam for us, respondent is present. In view of the above submission made by Mr. Islam, Land Council for the petitioner, the petition is dismissed. On withdrawal.
Wait, please, my lord. Lord, with the due consent of the other side, I beg to mention item number 30 and 32. My senior is not well, so kindly take up this matter on some any other day.
30 and 32.
30, 32.
Okay. On the prayer of MS.
M. Bharati.
M. Bharati, Land Council for the petitioner. The case is passed over for the day. Mr. S. Cal, S.C. Cal, Land Standing Council. GST is present. Same 32.
May I please, Your Lordship, item number 40 may not like to take up the matter.
40. Okay. Okay. Leave this case before any other events. Take it.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 45. Lordship, I may be allowed to withdraw the petition. It is infructuous.
Okay. Miss
R. Bora.
R. Bora, Land Council, appearing for Mr. A.R. Bori, Council for the petitioner, has submitted that the petitioner wants to withdraw the petition. Miss S. Bora, video present in view of the above submission. Video dismissed on withdrawal.
Oh, please.
May I please, Your Lordship? Lordship, I beg to mention for listing a land acquisition matter, Lordship. Kindly, this matter may be listed on.
New case of
Lordship, before vacation, Lordship, it has come on motion, Lordship.
admission.
Now admission.
Side of admission order, video.
One and Yeah, please, Your Lordship.
Yes.
The subject matter, Lordship, is infructuous, Lordship, as the tender bid, Lordship, is already work is all completed, Lordship.
Mr.
Why would we, Lordship?
Y. Borvia. Black Land Council. For the petitioner. Mr. Bugo, you are there. Central Government Council.
In respect to item number 1, Lordship.
Okay. Central Government Council. For all the respondents
Lordship.
are present. Mr. Borvia has submitted that as the contract work is already over, subject matter of the petition has become in view of the above submission made by Mr. Land Council for the petition. The petition is dismissed as infructuous. Same in the other one.
Lordship. Same.
You are a council. MS
MS, NP Manpung.
and the
NP Manpung, Lordship.
for
B. Deca. CGC B. Deca.
B. Deca.
Lordship.
Well, in this case, also, I have the written instruction to withdraw this.
Okay. Mr. S.K. Roy and Council for the petition has submitted on instruction that the petitioner wants to withdraw the writ petition. Mr.
U Sharma appearing on behalf of Miss N.
R.V. Sharma, learned counsel, representing
Miss N. Bora. Standing
N.
counsel.
Bora
Bora.
and standing on Panchayat and Rural Development Department for the respondent number 232 and 6 as Borwa. 1, 3, 4, 5 are present. Dismissed.
Made, please, your Lordship. The matter relates to my mismatch of ITC. In fact, as per the imping order, we have already made the payment. At this, is the notice will go on.
Yes, Mr.
Yes, madam. Only notice.
Okay. Appellate form is not there.
Not there, madam.
Hmm?
In fact, it is constituted, it is yet to be functional, madam. I have mentioned under section 109.
Otherwise,
My lord, it will go there.
chairman has been appointed.
But it is yet to be functional.
Hired Mr. A. Goel. Learned counsel for the petitioner. Petitioners, Mr. and Mr. B. Goel,
All the respondents.
learned standing counsel, Finance and Taxation Department, Assam, for all the respondents. Full stop. You are challenging an order, appellate order,
My lord. 5/11/2022.
in this writ petition, come on. The petitioner has assailed the legality and validity of the judgment and order dated 5/11/2020 passed by the Joint Commissioner of Taxes, Guwahati, against an order dated 5/11/2022 passed under the provisions of the Assam Goods and Services Tax 2017. Postmark. The petitioner has prepared the writ petition on the premise that the appellate tribunal required to be constituted under section 109 of the Assam Goods and Services Tax Act 2017 has not yet been issue notice returnable in progress, as Mr. Gokul. So instruct has appeared and accepted notice on behalf of all the respondents. The issuance of formal notice stands dispensary. Counsel for the petitioner has, however, furnished requisite number of extra copies of the writ petition along with an extract from Mr. Gokul within 3 working days.
Deeply obliged.
May I please, your lordship? Lordship, this contempt petition has been filed by for violation of your lordship's order dated 11/8/23, my lord, passed in WPC 251421. Is at at Annexure 1, page 14, my lord.
Annexure 1,
Page
yes.
14, my lord. The operative portion is at page 23, my lord, paragraph 14. May I read, my lord?
Hmm.
But considering the above, the instant writ petition therefore stands disposed of, directing the respondent number 2, 4, and 5 to make necessary verification as regards the supply so made by the petitioner, and thereupon, if it is found that the petitioner is entitled to the said amount claimed in the writ petition or such other amount as is found due on the basis of the verification, the said amount be paid to the petitioner. In that regard, the respondent number 1 and 4 may submit appropriate proposal before the respondent number 3 for sanctioning the said amount if the budget had already lapsed, and the respondent number 3 shall also take appropriate steps so that the petitioner gets his entitlement. the said exercise be completed within a period of 6 months from the date a certified copy of the judgment is served upon the respondent number
Yes.
5 respectively. Now pursuant to your lordship's order, my lord, we have approached the authorities, my lord, on 31/8/23 and on 4/9/23. Subsequent thereto, my lord, an amount has been paid to us, my lord.
Hmm.
Amount of, my lord, around 90 lakhs out of 1 crore 46 lakh has been paid to us, my lord.
Hmm.
And now the total balance amount remains at 27 lakhs 79.
So, amount has been quantified. Amount has been assessed, verified.
That has been done, my lord.
Okay. Hard.
And my lord, along with the 27 lakh 79,850, my lord, an amount of rupees 2 lakh 81,258
Okay.
also needs to be paid
Mr.
regarding
T.
that
Kolita.
which was deducted.
Learned counsel for the petition. The contempt petition. He has preferred alleging non-compliance of the direction made in a judgment and order dated 11/8/2023. Passed in a writ petition WPC number 2514/2021. Post office. The petitioner has averred that after the judgment and order dated so and so, the petitioner had brought the same to the notice of the respondents. Post office. Pursuant to there to comma, the respondents have only released a part of the outstanding amount. Post of it is ever that as on date, comma, the balance amount of rupees 27,79,850 along with an amount of rupees 2,81,258, comma, which was wrongly deducted as VAT, comma, are yet to be disbursed to the petitioner. Issue notice returnable in police. The petitioner shall take steps for service of notice upon the respondents by registered post with AD within 3 working days.
Obliged, my lord.
Item number 5.
May it please your lordship. Lordship, here the petitioners are residents of 2 villages in Karimganj district, your lordship. The names are Damchara, Tripurapunji and Mohanpur, your lordship. They had settled in these villages over the last 5 decades at different points in time, your lordship. Some of them were evicted on 4th of November 2023, your lordship. Your lordship, petitioners number 1 to 44 had also applied for settlement of these lands, your lordship, but all of their applications were rejected, your lordship. All the rejection orders I have annexed, your lordship. They start from page number 212.
Hmm.
Now, your lordship, they are being threatened that those who are evicted are also residing there itself in the houses of relatives or friends because, your lordship, they are landless. And the others also are now under the threat of eviction, your lordships.
Now, with the rejection of your application,
Lordship.
at least a prima facie observation against you.
Lordship. But we were not able to prove that we were present in this state of Assam
Now,
for 3 generations.
What is the after rejection of this application? These are all under what?
Lordship, during the
This is for what service?
which page, your lordship?
Say, for example, 210
Yes, your lordship. This is our application acknowledgement
acknowledgement.
for settlement, your lordship.
And then where is the observation?
Lordship,
Observation page 213.
213, your lord.
213.
Yes, your lord.
1-3.
Now, is it an appealable order?
Lordship, the fact is that we are not, that is government land, your lordship. So our prayer is that even if we are evicted, your lordship, then also if we are forced to go somewhere else, we'll remain as encroachers, your lordship. And in clause 15 of the
The
Assam land policy,
observation which is there,
lordship,
suppose say I have just read one,
lordship,
page 217.
lordship,
Now, this observation is made qua the land policy,
lordship,
right?
lordship.
So there are some questions of fact which are required to be determined.
Lordship,
Say you do not fulfill the criteria of an indigenous person as per the definition of indigenous person.
lordship,
So on that ground, your application has been rejected.
lordship.
Now, if you have a claim on that you are an indigenous person, you have to establish somewhere how to do. What is the forum? Is it an appellate order? Yes, Mr. Borwa, is it an appellate order?
No, also this is a mission Bosundhara has been initiated. So accordingly, he has to prove that for the last 3 generations, he or she is residing in that place. So for that matter, the documents are required. And those documents, based on which documents they have uploaded, we have gone through and finally a decision has been arrived at that already they are encroachers over government land. So that's the end of the matter. And if at all they are claiming for a settlement over a different plot of land, then another document has to be submitted. But that is the documents which have been submitted in the petitions are also submitted before the authorities, before this decision has been arrived at. So this is not an appealable order. Now they cannot be saying that previously they were claiming over land A, now they cannot be claiming over land B. So ultimately, these are 2 different plots of lands, if at all they have any right over there.
There is settlement of khas and ceiling surplus land.
217.
You can issue notice of this case, Mr.
Lordship,
But if
But lots of,
observations are there,
in fact,
prima facie observations are there, difficult for you.
prima facie,
lordship, our prayer is primarily for rehabilitation, your lord.
Right, but even if you are not, say, eligible for settlement,
Lordship. This,
then you are not eligible for rehabilitation also. Because if this observation remains,
lordship,
try to remove this observation, and that is, for that, I don't think that proceeding is a proper forum. You have been, I think few criteria are there
Lordship.
to whatever
Yes,
in
your
the mission Bosundhara, that these are the requirements. Now they have made an observation that you don't meet those requirements.
lordship,
So if you are not eligible to be settled or allotted, you are also not eligible to be rehabilitated.
yes.
If this observation remains, and these are to be decided perhaps not in a writ proceeding, perhaps.
lordship,
And in fact, yes, that's true. And lots of the first line, the beginning line of this finding is very clear. Only in recent days they have encroached in a very organized way. So that is very clear. And for that reason, the rejection has been done, not because they don't have the sufficient documents to prove that. So ultimately, they have got a bunch of documents. I'm unable to trace out who is submitting for what document. So it's kind of a
Hard Mr. As the Learned Counsel for the petitions. And A. Bhattacharya, Standing Counsel, Revenue and Disaster Management Department, for the respondent number 1 and 2, and Mr. S. Purua, Learned Junior Government for the respondent number
3, 4,
4 and 5. Stop. The petitioners have approached by this requisition being agreed by rejection of their applications. By whom?
by the circle officer, your lordship,
For settlement of khas and ceiling surplus land in their favor by different orders. Annexed as annexer.
Next are 3 series, your lordship.
Annexer 3 series. Issue notice. The petitioners have also prayed for
District disaster management unit. District disaster management.
rehabilitation, their rehabilitation in appropriate government land. The petitioners have also sought a direction to the state respondents not to evict them without first rehabilitating them. Issue notice returning in 4 weeks. As so and so appears. No formal notice, extra copies within 3 working days.
Lordship, here it is a case of non-payment of contractual bills, your lordship. The petitioner had entered into an agreement with the District Disaster Management Authority of Sibsagar, your lordship. The petitioner is a hospital, your lordship. So they were engaged to
What is
provide,
the amount?
lordship, the amount is 80,79,320, your lordship.
Where have you mentioned?
Lordship will find that page number 24, the annexure, your lordship. Our last representation. And along with it is the bill, your lordship, the summary of the bills.
Yes, Mr. Bhattacharya. State Disaster Management Authority. You. Oh. Heart, Mr. S. Learned Counsel for the petitioner. A. Bhattacharya, Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. And Mr. S. Borua, Junior Government Bugasam for the respondent number 2, 3, and 4. The case of the petitioner, in brief, is that the petitioner is a healthcare establishment and it had entered into a memorandum of understanding with the respondent number 3 for disposal of biomedical waste generated in quarantine centers and treating centers for COVID-19 pandemic. Post of the petitioner raised bills before the respondent authorities from for its dues amounting to rupees 80,79,320. Full stop. As the said amount is not yet disbursed, the petitioner has approached this court by the read petition. Issue notice returnable 4 weeks as so and so appeared, accepted. No problem. This extra copies, 3 working days.
Much obliged.
Please, Lordship, I kindly pass it over for the time being.
Yes, Mr. Ganguly.
No, he has filed a similar application before the recovery officer also. The IA that is there listed before your lordship today, he's made the same prayer before the RO, and the RO has fixed it for 23rd of August. There is no meaning of this.
Lordship, let it be taken up after some time. We'll set it
And
there.
what is the amount?
Amount remaining now is around 3.5 lakhs. He can pay it, but
Take
Yeah,
a call.
yes,
Take a call because he has made maximum efforts.
yes. No, we are not saying pay it today because the RO has already granted him sort of time, not in so many words, but the order, if your lordship says that we are to file a, that order is in the IA Civil 1408. And at page
Which?
at page 16, my lord, this is his application dated 9/5/2024.
Order,
My lord, the order is at page 21. lords.
he has paid.
Yes, my lord, page 21. He has paid the earlier amount and now for the balance amount, he has made a prayer that I should be granted time.
So RO is in staging of the matter?
Yes, and exactly the same prayer is made before your lordship.
Okay, let Mr. Mitro.
That- I can make.
May I please, Lordship? Also, the Assam Industrial Infrastructure Development Corporation, in order to expansion of their industrial area, my lord, acquired certain land under right to fair compensation 2013 from Deputy Commissioner Kamrup Rural. Now, for that purpose, my lord, on 9/2/2022, award was given, my lord. And pursuant to that, the beneficiary also received the amount. Afterward, on 18/8/2022, an application was made for the purpose of redetermination for purpose of, my lord, as a case of reference, my lord. Now, this case was, my lord, thereafter forwarded to the from Deputy Commissioner Office to the district judge on 28/11/2023. Now, Lord, see the requirement of section 64 demands
64.
right to fair
Fair
compensation. Section 64, page 37.
Yes.
64, Lordship, can you see the line start from? Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred to the collector for the determination of the authority as the case may be, whether his objection to be measurement of the land, the amount of the compensation, the person to whom it is payable, the right of rehabilitation, resettlement under chapter 5 and 6 of the appointment of the compensation among the person interested, provided that the collector shall, within a period of 30 days from the date of receipt of application, make the reference to the authority concerned. Provided further that where the collector failed to make such reference within the period so specified, the applicant may apply to the authority as the case may be by requesting it to the direct to the collector to make the reference to it within a period of 30 days. The application shall state the ground on which objection to the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at the time when the made his award within 6 weeks from the date of the collector's award. In other case, within 6 weeks of the receipt of the notice from the collector under section 21 or within 6 months from the date of the collector award, whichever period shall first expire. Now, next line is important. Provided further that the collector may entertain an application after the expiry of the said period within a further period of 1 year if he satisfied that there was sufficient cause for not filing it within the period specified in this first provision. Now, Lord, see, the whole case is set up for limitation. Because, my lord, the projects are such a, my lord, in a way of design that amount has to be paid, property has to be acquired, then project to be started. That's why, my lord, the time limit has been framed. Here is a case, my lord, not a single whisper from the part of applicant that he has caused delay for what reason. And second aspect of the matter, that even the deputy commissioner not look into this aspect that whether this petition is maintainable or not on the ground of limitation, my lord. This whole issue of limitation has been mastered. The practice is that, my lord, somebody apply before that, my lord, deputy commissioner office, he put the signature, get a date, and my lord, immediately it has been referred directly to the deputy commissioner to the district, my lord, judge office, my lord. In between, my lord, I don't feel that even it has been brought to the notice of the deputy commissioner for the purpose of any consideration. Apart from lordship, the section 65 also demands certain information has to be provided along with the application to the deputy from deputy commissioner office to the district judge, my lord. That assessment, value, property details, everything, my lord. Here in case, my lord, that simple this application was forwarded from deputy commissioner to the second part to the, my lord, authority concerned, my lord. Question is that, my lord, limitation is paramount. My lord, there are numbers of judgments say that if suppose limitation is not dealt with, my lord, then this application liable to be rejected at threshold stage, my lord. This treatment has totally been ignored in this instant case, my lord. Second aspect of the matter, my lord, this issue has been dealt with by the, my lord, Honorable District, Additional District and Session Judge Amin Gao. But Lordship, a notification is that, 2020, Amin Gao, my lord, the Honorable District and Session has no power, my lord. The area has been conferred to the, my lord, Honorable District and Session and Metro, my lord. Therefore, my lord, the court has not vested with the proper jurisdiction, my lord. My lord, last notification is, my lord, page, second page, my lord. Lower Assam, Central Assam, North Assam, Upper Assam, and Barak Valley, my lord. These are the, my lord, area divided, and the respective court has been formed, my lord.
Okay, now where it was forwarded, referred.
My lord, referred to the District and Session Judge, Amin Government.
Now, have you raised this jurisdictional issue in this petition?
In this petition, my lord.
Yes.
My lord, about that jurisdiction issue, my lord, because my lord, yesterday we have got only this notification, but about that limitation part we have raised, my lord.
No,
Limitation part.
for jurisdiction issue,
My lord.
have you raised that issue a pleaded case here? That
My lord,
because of this
lordship,
notification-
I escaped, my lord, because yesterday, my lord, I have got only this information, my lord, notification.
So without
lordship-
raising that issue,
No doubt. I just got to a lord, but lordship limitation is paramount, my lord. I have given one judgment, lordship. Kindly look for a moment. The flag mark.
under 2013 Act.
Yes, my lord.
Yes.
My lord, that flag mark, my lord. The whole issue has been dealt with in regard to limitation. Only one line I would like to read out. An unlimited limitation would lead to a sense of insecurity and uncertainty, and therefore limitation prevents disturbance or deprivation of what may have been acquired in equity and justice by long enjoyment, or what may have been lost by a party's own inaction, negligence, or lesser. When the project is set up for a certain time period, my lord, amount is also determined. Somebody approached, my lord, with inordinate delay.
Has he directly dealt with this 64 first proviso?
My lord, 64, my lord.
Because on a privacy view, if you read both the provisos together,
My lord.
then that issue of limitation is diluted.
My lord, limitation, my lord,
See the second proviso.
what it? But second proviso says that is the provision.
There is no limitation.
My lord, this section 64 is very much.
Is there any limitation for the applicant?
Yes, my
Make
lord.
an application.
Yes, my lord, because my lord, he is
Read once
Yes.
again.
provided one, clause A. If the person making it was present or repented before the collector at the time,
Second proviso to subsection.
but that is 21 in respect, this is not connected to this section 21 at the initial stage of my lord application, my lord.
64 I am reading.
And yes, my lord, section 64 comprises two parts, my lord, A and B. A in connection with application, once award is pronounced.
I am saying about 64 subsection 1.
Yes, my lord.
There is, you are harping on first proviso to subsection 1,
Yes, ma'am.
right?
Right.
Your case is based on first proviso to subsection 1 of section 64.
Ma'am.
Now please read second proviso, subsection 1.
The application shall state the ground thereafter provided that,
Oh, you are reading somewhere.
my lord,
See the second proviso. Second proviso.
yes, yes, ma'am. Second provision. Provided further that where the collector fails to make such reference within the period or so specified, the applicant may apply to the authority as the case may be, for requesting it to direct the collector to make the reference to it within a period of 30. It has also not been complied with, my lord.
No. Suppose your repetition is allow those. Still the applicant has the right to make an application before the district judge to make the reference.
No, well,
Why not?
my lord, reason is that, my lord,
Why not?
my lord, the procedure laid down is that,
Mr. Day before yesterday, Supreme Court has observed 40 years or 50 years. Land acquisition
yes,
matter.
yes, my lord, we have got it, my lord. It's surprised, my lord, about that.
Too technical.
Yes, well.
This,
Yes, Lord.
your petition is too
Lord, see,
technical.
what I'm saying, my lord, the,
Because second provision makes the, makes it very diluted.
yes, sir. Yes.
Applicant has no limitation period. Suppose you're on that ground that a collector has not referred the matter within a period of
30 days.
30 days.
Then he has to,
Then applicant has unlimited period. There is no limitation period. See,
but 30 days.
then he has to make the application
My lord.
before the district judge.
My lord.
Right?
Yes, ma'am.
That direct the deputy commissioner to make the reference within 30 days.
30 days, my lord.
No. Direction to the deputy commissioner
Exactly, my
to
lord.
make the reference. But for the applicant, is there any limitation period?
Yes, my lord, because, my lord, if we
You
read
have
the
to
first,
read it, the concept
my lord, there,
in whole. You cannot pick up one proviso.
but it is interconnected with the first provision, my lord. It is interconnected with the first
I
provision.
think this might be a
My lord,
misunderstanding.
reason is that, well, the first part is clearly that 30 days is the period given to the deputy commissioner for reference. Suppose it failed, then the person applicant would
Assume
fail.
it
Then the
is- it
applicant has to move to
what is the
applicant.
limitation period for the private respondent?
But,
Make an application before the district judge. What is the limitation period?
my lord, that limitation 30 days, my lord.
Read it properly.
Yes, ma'am.
Once
Provi-
again.
My lord, we have to read together, my lord. Provided further date where the collector failed to make such reference within the period of so special, that is 30 days. The applicant may apply to the authority as the case may by requesting it to direct the
The
collector
applicant
to,
may apply to the authority
yes,
as the case may be. Okay.
because in this case it is not applied. Yes, ma'am. Yes, yes,
Now read. Requesting it
within a period. Understood, my lord.
to direct the collector.
That is the, but,
Direct the collector.
my lord,
He has to make the application that I'm requesting you,
I got it, lordship, but there is no limitation. But understood, lordship.
collector, make the reference to me within a period of
Quite right.
days.
Lordship, quite right.
Now, where is the limitation period?
I
for the
understood, I
applicant?
understood, lordship, I got it, lordship. But lordship.
You
in the-
understood?
Understood. Right.
Now, if
No.
we read together, it is not a mandatory provision.
My-
That limitation is somewhat diluted by this second provision.
But in this case, ma'am, this provision will not attract.
Jeez.
Yes, ma'am. This provision will not attract in this case because here is a case, the case has been referred by the deputy commissioner to the madam, concerned court, madam. But the limitation part,
This issue, but I don't think.
madam, limitation part has been totally ignored.
Because, question of Article 300A is involved here.
Yes, ma'am.
Question of, and this, I don't think this is.
But there are two issues, madam. First is about the jurisdictional part, madam.
Question you may raise, that is, but here it is not raised.
Madam.
If the jurisdiction issue is raised, if this notification is still holding the field,
Madam, madam.
then that
But there is no notification afterward, madam. I have got it, madam. 2020, the last notification.
maybe it is continuing.
Yes, madam. There, I have,
Maybe. That could be a ground to examine. Lack of jurisdiction is a nullity,
madam.
right?
Madam, second practice,
You cannot assume jurisdiction
madam.
of
But-
a jurisdictional fact which he does not have.
Madam, madam.
That has to be provided to him. Now, apparently, District Judge Amingao might not have the jurisdiction
Quite right,
to
madam.
decide a reference under Section 64.
Madam, madam.
But that is not your clear case here.
Right now, my lord. Therefore, my lord, what I am saying, my lord, limitation the paramount questions, if suppose it has been ignored by, at my lord, threshold stage by the deputy commissioner, either by the parties concerned.
Show me anything, and this is not directly answering to the question, please judgment.
My lord, kindly see,
Is it dealing with that?
my lord, yes,
Where is that?
my lord,
It is dealing with what act? Please tell me.
my lord, application under section, lordship, page 18, my lord,
Page
18.
18.
The application forwarded by the person concerned. That is under 2013 Act,
Page 18.
1818, my lord.
How we can find out page 18? Or you can tell paragraph,
My lord,
because there is no page here,
sorry, my lord, extremely.
no
My lord,
pagination.
land reference case 8 of the 2023 of the application. No, my lord, read petition, my lord. Sorry, my lord.
No, that is the factual part where it has dealt with this judgment.
My lord, the judgment, my lord, it speaks about.
Dealt with first proviso
Yes.
and second proviso together, which
No, my lord, that is not a first proviso. Second, it directly come to my lord about the that limitation part, my lord. It has been.
it has dealt with which part
My lord.
of the 2013 Act?
Yes, 2013 Act.
Which part?
Yes, ma'am. Here, my lord.
This is dealing with
My lord, this deal with
dealing with
74.
section 74.
But limitation has been. That is only the my lord, reflection.
That is appeal.
Quite right, my lord.
And it is very specific.
Yes. My lord, 74. But
Appeal is very specific.
quite right, my lord. 74 deals with, my lord, no doubt appeal. But limitation is a question, my lord, which cannot be ignored, my lord. And another judgment, lordship, I have given on citation of the Honorable High Court of Bombay, where, my lord, on the ground of limitation, the case was rejected.
Now we are also with example 50 years. So, Mr.
My lord,
this is
can you
too-
see one citation I would like to
too
relate?
hyper-technical.
No, my lord, it's not hypertechnical. My question, the limitation is bypassed, my lord. Really, my lord, it's such a practice going on, my lord. Lordship has need to examine the issue that why this limitation need not require to be dealt with, my lord. There must, my lord, some answer, my lord, either from the applicant or from the deputy commissioner office. Because
Okay,
project,
tell me which one, this second judgment?
my lord, that is Sainath Devrao Janjan. My lord, in paragraph
What is the
2,
period involved here?
my lord, the period is, my lord, the delay was there for making application. Paragraph 2, it was rejected. Paragraph 2, it was rejected. And thereafter, my lord, he raised the issue. Paragraph 11, lordship may kindly look into. In paragraph 24, my lord. There are lots of judgment in the similar line of other high courts, my lord, I have found that 64(2), if not complied with, my lord.
Now, what is your sequence of events?
Yes, my lord. Sequence of event, my lord, 9/2/2022 award pronounced.
Where is that? List of dates?
Yes, list of date. Otherwise, lords may note down. I can, my lord, on the basis
No
of.
list of dates.
Yes, my list of date, my lord, contain. Page. List of date 9/2/2022. After synopsis.
1 minute. What is the land reference case?
My lord, page 18. Downside signature 18/8/2022 of the office of the deputy.
What is the award?
Award in page, my lord, 30. 30. Announced, pronounced on 9th February 2022.
No, this is under 6-1.
My lord, My lord, yes, my lord.
But you are raising some technical issues. This
My-
is on the sixth one,
Yes,
Assam Land Requisition and Acquisition Act. Now, has it been amended?
My lord, yes, my lord.
Six is amended.
My lord, that approximately
Huh?
2013 come into play, my lord.
Assam Land Requisition. This is an award under. Okay, we'll issue notice.
My lord, entire issue, my lord, dealt with under 2013. There is no doubt to that
It
effect.
is, it will be a Assam Land Acquisition. Land Acquisition. 64. Good. It's about 1894 Act.
My lord,
1894 Act.
yes, my lord.
Section 6
Lordship, kindly
speaks
see-
about.
Yes, my lord.
1 minute. 9 February.
Now, if lordship see their
9
reference,
February. When they made the application,
my lord, this application was made by them on 18/8/2022, page 18. Left side signature contained.
now where is the reference order?
My lord, reference order till yet not pronounced. The case is under the my lord subject matter we have received notice and we
No,
came
no.
to the.
Where is the reference order of the Deputy Commission?
There is no reference order, my lord. Straight with this application, we have forwarded to the, my lord, that is the practice is going on, my lord. That's why, my lord, raising questions, no information, nothing, my lord. Straight with this application was forwarded there and we have received the copy, my lord.
Receive what, which copy?
18, my lord, page 18,
Page
1818.
18. Have you raised that issue
My lord,
before the
my
reference
lord,
authority?
yes, but this, my lord, matter is fixed on 20, my lord, next week. We would like to suppose submit our, my lord, reply, but question is that lordship, can you see for a moment, section 65 for a moment? What duty casts upon the deputy commissioner? It is a blanket formality that has been observed, my lord. Section 65.
And there is a prescribed form I have seen.
Yes, yeah, quite right, madam.
He used to fill up those forms.
Yeah, and that's why 65 is, yes,
Form,
Yes, yes, yes.
Finally, without anything, he will not forward.
my lord.
Without anything, he will not
My
forward.
lord, that's why, my lord, records are necessary.
Mr. Borua, get the reference form. Everything will be clear.
In fact, the date of,
Jurisdictional issue is one thing,
My lord,
which you have not raised.
my lord will.
he is only harping on the limitation.
Limitation. Now, this authority, Deputy Commissioner, has otherwise jurisdiction to entertain a petition for a period of 1 year, provided sufficient cause is found.
Quite right.
That is his discretion. Applicant cannot,
Well-
preparing authority cannot question that. But if he has made the formalities in the reference form, there is a prescribed reference form.
My lord, quite right.
He has to fill up. This is the award, date of the award amount,
Land details.
so and so land required, and forward it along with the application.
Being
He makes
satisfied.
a statement that I am satisfied with the
My lord.
reason for delay because they perhaps have made something
Right.
in the application, applicant. Paragraph 15. That this application has been preferred within 6 weeks from the date of receipt of the amount of compensation or award. specific statement.
What's the page?
Paragraph 15,
Yes, ma'am, I've got it.
clear statement
Yes, but
from
it,
the
my
applicant.
lord, has been prepared, has been,
So say, yes, I'm satisfied.
it is a matter of examination, my lord.
Unless it is unnecessary exercise.
It required to be, he made a statement, but the date
Just
contains.
have his reference form, that's all.
Yes, exactly, my 1880 is the date, my lord, required to be.
Reference form he is to fill up,
Yes, my lord.
that is mandatory.
Now, lordship, one aspect
Let
is
him-
very important, that he made a statement, paragraph 15, that within 6 weeks, he has prepared. But lordship, page 18 clearly reveals that the date of receipt of his application before the authority concerned is 18/8, my lord. Left side, my lord, this is the signature of the office of the deputy office.
No, that form will contain everything.
Madam.
I have seen these kind of forms.
Yes, yes, I have also gone. Lordship, may I pray,
Get
my
the
lord,
reference form. That's all.
It will make things clear.
my lord, my humble prayer, my lord, 20 is the date for, my lord, lordship, may kindly give little protection, my lord. My
No,
lord,
no
otherwise, my lord,
protection. No protection, absolutely. You are a state. You are a state,
Right.
an instrumentality of the state.
quite right, man. But my say,
You have acquired land
Right.
from
certain person, my lord.
citizens.
Right. But we have
And
only,
their rights under 300A is involved.
yes, no,
They have every right to protect.
quite right.
And this is a beneficial legislation.
My lord,
And you are the acquiring body.
my lord,
The acquiring body needs land. You have to pay due compensation. That's all.
yes, my lord,
But
definitely.
these are technicalities we are examining.
My lord, otherwise, my lord, what happens, suppose on this
65.
ground of limitation, it will not stand, my lord. The further exercise contemplated by that, my lord, authority will not, for the timing, my lord, protection may be given, my lord.
the statement submitted by collector, Mr. Borua.
Yeah.
The statement submitted by the collector
Hmm.
while forwarding the reference
Hmm.
under section 65. That should contain, that will contain everything.
Yes, we'll have it.
And second aspect, my lord, that
Scan copy will do.
my lord, suppose my so on this score, my lord, of the this issue of limitation, suppose this it will be succeeded, my lord. The further exercise, whatever contemplate, but otherwise, lordship may definitely will remand back to the deputy commissioner for a moment, my lord, for reconsideration of the limitation issue. For a moment, my lord. Then the proceeding which is presently pending before the authority concerned, my lord, it
Oh,
will parallelly.
in this petition, your only pleaded case is on limitation.
Limitation.
Quite
right.
right, my lord.
Your pleaded case is not on jurisdiction.
Not at-
Absolutely, my lord.
Right. So had it been the case, jurisdiction goes to the root of the matter.
My lord.
But here it is not your pleaded.
Right.
We are only examining section 64, proviso first and proviso second.
Uh,
And it appears to be an
Lordship may
it is not
kindly,
deeply applied.
my
But
lord,
since you have raised the issue, we'll examine the issue.
but parallel
think
proceeding, my
you-
lord.
It calls for an interim order.
My lord, give us a liberty to, my lord, raise this issue in this.
You are always at liberty. You are always at liberty. You can raise both issues.
Fine.
I think before the authority
Yes,
that you don't have jurisdiction,
no, unlimited.
don't assume jurisdiction.
Yes.
These are no notification.
Fine.
Don't assume jurisdiction. Then if he passes that I have the jurisdiction, yes, then you can definitely come by a repetition. Right? But you have to raise the point of
Yes,
jurisdiction
on 20
before him,
But
as well as the point of limitation. Since you are hesitating, we are
Lordship, what the practice actually, Lordship, what happened, what I feel, my lord, in maximum cases, my lord, that there is no proper guidelines which has been otherwise issued by that concerned office or whatever, my lord. The
No,
practice
no,
is.
otherwise he is mandatorily required to
Exactly, my lord.
fulfill section 60.
Yes, my lord, that's
That is there. And you should have gone to that authority, reference authority. Everything was available there.
It was present there.
You are hesitating something. We don't have the records.
my.
Heard Mr. Somori. I counsel for the petitioner. And Mr. S. Burua.
All the respondents.
Learned junior government to prepare some for all the respondents. Here again, district commissioner cannot represent state or some. That's one number one.
Yes, had been,
One and two, one and two. One and two, huh? The writ petitioner, comma, and instrumentality of the state under Article 12 of the Constitution of India, comma, has raised its grievance as regards the period of limitation laid down in the first proviso of subsection 1 of section 64 of the right to fair compensation and consequence in land acquisition, rehabilitation and resettlement Act 2013 within bracket TLARR Act. Full stop. It is a case of the petitioner that the award was passed
No, check, no, check, no, check.
Who is the award?
the award is not there.
My lord, award,
yes,
my lord, award in page 3301.
No.
Mr. Somoria, this is a notification under section 6
Yes, my lord.
of the 64 Act.
Yes, my lord.
Then thereafter different procedures.
My lord.
Thereafter assessment of compensation.
My lord.
Then thereafter putting them to notice. Then award.
No, prior to that, but afterward, my lord, this my lord, has been issued, my lord, on 9th February
Mr.
2022.
See, Mr.
My lord, reason is that,
Somoria,
my lord,
please.
my lord, record may kindly call for, we have.
No, please, why should we call for the record, mister?
My lord,
You are the party. When did you pay the amount?
my lord, we have paid the amount, my lord. We have paid the amount on 3/4/2022.
3/4/2022.
Yes, my lord.
3,
Yes, my lord.
so definitely 3/4 or somewhere
Handing over position was given to us.
3/4.
No, my lord, the amount we have paid on 3/4/2022.
So this is not the award.
But award, my lord,
Still,
notice is there, but.
notification under section 6. Please, is pleased to
My lord,
decide the acquisition.
Lordship, yes, I have the award, my lord, page 35, my lord, page 35, sorry. 35, my lord.
35.
6 crores 74 lakhs. This is the entire amount.
What is the date?
My lord,
Mention
9/2/2022, my lord,
Huh?
column 6,
Column?
okay, which is effective from 9/2/2022, date of notification. And the,
No, please page.
my lord, column 6,
Column 6.
Column 6 of page 35.
35.
page 35, column 6, which is effected 9/2/2022.
Column 6.
Third line, my lord. Column 6, third line, which is effected from 9/2022 to 6/4/2022, 57 days interest was paid to them. And that,
It is estimate of preliminary cost.
my lord, column 6, my lord, additional compensation 12% per annum on the total market value. So
No, Mr. Somoria, please see at the top.
Yes, my lord. Estimated preliminary cost of the, because my lord,
Preliminary cost.
and based on that, my lord, afterward we have made the payment, my lord, to the Deputy Commissioner Office. On 3.
It is not award, mister.
Yes, ma'am.
That is preliminary cost. You have raised some issue with specific dates. Now, you are not sure about the award, date of the award.
My lord, the
When it is bereft of necessary details, why should we entertain?
And my lord, so far, my lord, paragraph 1, if your lordship see the petition, reference petition, page 20, they have relied upon this document, my lord. 9/2022.
I think, Mr. Borua, you better get the date of the awards.
The petitioner was also on the previous occasions he have been asked.
No,
produce
award,
a copy.
my lord, that detail was not asked from me.
No.
That
No, that was the point which has been the court has come and culminated. And that apart, the second respondent has been
These
deleted.
are all deposit of fund by the requiring authority. These are all prior to, anterior to the award and disbursement,
Yes,
right?
yes.
We are not sure whether award has been passed or not, because from the application also, there, that deputy commissioner has fixed an amount based on wrong zonal valuation.
Okay.
That is what,
Yeah.
whether it is award has been passed or not, that is also not
For
sure.
the sake of calculation
Why
of,
should we enter in without knowing the facts?
Yes.
Both should
my lord, we will
place
try.
the date of the award.
Definitely, I will try.
All otherwise will be futile exercise.
No, lordship will inform, my lord. Definitely, I will collect.
And as an instrumentality of the state, if you raise, then it will have you possibly.
No, lordship will inform, my lord. They know.
You are an instrumentality of the state. You are part of the state.
My lord, I will inform.
Raising doubt about your,
My lord, I
own-
will get the
that is
information about date.
quite serious.
Yes, definitely.
Both Mr. Somaria, learned counsel for the petition, and Mr. S. Borua, learned junior government advocate, representing the husband number 1 and 2. Shall place.
Date of
Respondent number, name of the respondent number 2 was deleted by the last order dated 22 government.
Oh. 1. Shall place, shall obtain instruction and place before the court.
My lord.
As to when the concerned award has been passed
Well.
by the collector. When? Take this, you can prefer another iteration on jurisdiction. Huh? When?
At 2 weeks time, my lord.
Yes.
Yes.
Weeks, read 36.
My lord.
Get sure about the date of
Yes,
the
yes, absolutely, my lord. It's my duty, my lord.
award. Oh,
My lord, both are interconnected, 8 and 9. my
which
lord.
one? 8 and
9, my lord. Next
9, same.
Same, my lord.
Okay, same.
My learned friend has come. Last occasions, my prayer was that I have already paid that amount actually. If I lordship go through my IA application, I stated that there was total liability of 18.550 lakhs.
3.5 remains.
Actually, for 2.7 lakhs, even 2.7
As
lakhs.
per my instruction, it's 3.5.
So, my lord, my submission is that, my lord, I have submitted one applications dated
But 6 months is too much. Is
Huh?
it not?
Huh?
For 2.7, paying for 6 months is too much.
the 13/5/24, my lord, I have submitted one application that it should be one, there should be one time settlement. I am
3.5 you have made clear that he
That-
has paid 15 lakh. And so and so, so and so. How much on that they remained? 3.5, 2024.
2.7 lakh, as per statement account 2.70.
Now, have you made any application?
Yes, my lord, I have paid and page 22, my lord.
Mr. Ganguly, consider, will not.
Lord, this
Observe it.
application I have taken instruction, my lord. We cannot go for OTS in this account. This is actually a fraud declared account.
No, fraud cannot be
Well,
declared because this is not,
let
that
me-
I-
my
in
lord,
that case,
let me submit, my lord. I am addressing the court. Because this is, my lord, I did not want to go into the question. This person obtained a loan pretending to be a doctor of the Guwahati Medical College and Hospital, whereas he is not a doctor. Well, let me say that much.
that is
Whether
not
it is
been proved,
declared
that has not been proved. They filed an FIR that
Lord,
was
we'll reject it. He can challenge it in whatever proceeding he wants. But that is my instruction, my lord. And RO has given him time in any case, my lord, till
It
23.
is there already.
Why
Why is the
parallel,
question of
proceeding?
entertaining a repetition?
my lord, my submission is that
I
let-
thought that you made a submission that 2.7 lakh remains. So I thought that let Ganguly consider because everything almost,
yes,
He
my
has
lord.
to pay the full
I have,
amount.
no,
That is-
my lord, I have submitted one application, that application.
and he has
that-
taken cognizance of it and posted the case on 9/5/10.
Yes, huh?
That date is wrong.
23/8.
Yes, the next date is 23/8.
23.
Proceeding no state, my lord, proceeding no state. That they are, that
File an appeal.
eviction proceeding
You
no
file
state.
an appeal.
My lord, that eviction proceeding no state, my lord, that
You
is
file an appeal.
appeal because already they are, that appeal, that already,
Provision is there.
Yes,
no, my-
Section 30 perhaps.
my lord, for 3 lakh rupees, I am sure, my lord, the RO will not go for an eviction proceeding.
Hey, I think section 30.
20, my lord, if your lordship go to 27A, my lord, 27(1).
Section 30, my lord.
Because-
Against the
If
order
I
of the
remember
recovery.
correctly, 30.
Yes, against the order of the RO. Yes.
Any order.
No, against the,
Suppose you have made any application for stay.
Well, this is an innocuous order, my lord. He has just fixed. for it.
He also, seeing his limitation, he
Yes.
thought it better,
Yes, stayed
let
in
us
hand.
post it on so and so that, so
Yes.
that enough breathing time is available to the applicant to pay back the
no,
money.
my lord, my simple submission,
And
my lord.
I don't think it is the case.
My lord, I'm ready to pay 1 lakh.
You are also appearing for bank.
Yes, my lord.
Tell me, this is my tenable order. As an
No,
officer of the
my
court.
lord.
Now I am putting the question.
27(1), my lord, that whether it is made, if we question maintainability comes, if you have to go through the pay 27(1), recovery RDB Act,
Recovery of.
debt and the bankruptcy act.
Recovery. Refund. This is debt recovery tribunal, recovery officer. I think against the recovery officer order,
Yes.
there is an appeal.
No, my lord, that recovery officer is acting as a officer of the, as acting the office, the power of, is already, already have the power of, the recovery officer has already availed the power of that presiding officer. That power is not given to him. But he has availed it. He's a 27(1), my lord.
Service is online.
Okay.
One B.
What people like it.
Recovery officer will be. Recovery officer will exercise transfer.
30.
30.
30.
30,
Appeal against the order of recovery officer.
my lord, my lord.
Not withstand the obstant the clause. Any person aggrieved by an order of the recovery officer made under this act may within 30 days from the date on which a copy of the order is issued to him prefer an appeal to that fact. Appealable?
Appealable. If he wants.
If
My-
he has made
my-
any
if you-
application for stay or extension,
But
any
if-
order, it is not restrictive.
Well, if you interpret in other way, just give to 27(1), 27, 27(1)(b). 27(1)(b) of that.
Now,
Where
See-
defendant agrees to pay the amount specified recovery certificate and procedure stated by the recovery officer, the defendant shall forfeit the right to file appeal against the order of the tribunal.
the defendant agrees to, where the defendant
Agrees to pay the amount specified in the recovery certificate
because
and proceeding as stated by the recovery officer,
pay,
the defendant shall forfeit right to file appeal against the order of the tribunal.
where defendant shall forfeit the right.
Yes. So in that case, my lord,
No. This is right to file appeal against the orders of the tribunal,
against the order of tribunal.
not against the order of the recovery.
No, my lord, if I agree one that I have agreed to pay the entire amount, then my right to file an appeal will forfeited. Once, because I have already stated in my repetition,
No,
two.
no, please understand. 1B, read again.
Yes,
Where
That the defendant agrees to
agrees to pay the amount specified in the recovery certificate. You agreed to pay?
I am agreed to
You
pay.
agreed to pay.
Yes.
And the proceeding are stayed already
Recovery officer.
earlier.
Yeah.
Then you
The
forfeit the right to file appeal
Appeal
against the
the order-
orders of the tribunal.
tribunal.
It is that order.
Please understand.
It is the order of the DRT, man.
DRT, when you agree
Not this order of the recovery officer.
to I'll pay the entire amount as directed by the tribunal, then you forfeit the right.
The defendant shall forfeit the right to file appeal against the order of tribunal.
Tribunal you don't equate tribunal with recovery officer.
No, ma'am.
Now come to this section 30.
No, that I know, that 30 I know.
And
That if
you have already pursued the matter, parallel proceeding. Parallel proceeding. Should you observe?
my lord, my prayer is that if they consider my one-time settlement, that will nice.
I'll observe, I don't think fine maintain rule. It is up to you. He has given some breathing time to you on his own. Why should we? And if you are agreed by this order, you file
No,
appeal.
not agree, my lord. Well, simple how submission because I have no other alternative, just to clean.
No, I am aware of your position, the efforts you have made to repay the amount. But question is also on the point of law. And since
But
it
my
appears
lord, if the some observation is given that by application of paying one-time settlement 1 lakh, let them
no,
look at.
that is also barred.
If they, if a court.
That is Supreme Court has 2-3 judgments. Don't make
No,
comment, don't make any direction regarding OTS.
Yes.
It is between bank and a borrower, and bank has the discretion. Don't
Yeah, that judgment is there.
mandamus. Clear terms.
But in my lord, in my one judgment is there recently by this.
Then
honorable High Court.
OTS of the provider. OTS cannot issue. There are many State Bank of India versus something. Third, Mr. as the learned counsel for the petitioner. Petitions. And Mr. A. Ganguly, learned counsel for the respondent
1, 2, and 3.
1, 2, and 3. The petition. Petitioners have approached this court seeking to invoke the extraordinary and discretionary jurisdiction of this court or discretionary jurisdiction under Article 226 of the Constitution of India. Assailing proceedings before proceedings, which is recovery proceedings, which is comma at present comma is pending before the recovery officer of the dates recovery tribunal, comma Guwahati. Full stop. From the facts projected in the petition, comma, it transpires that on an application being made, comma, the respondent may provide a sanction letter dated 9/9/2014. Sanction an amount of housing loan,
My lord,
housing loan,
housing loan.
sanction an amount of rupees 24 lakh in towards housing loan in favor of the petitioner. Full stop. The loan account of the petitions had become non-performing asset NPA on 30/9/2016. Full stop. Thereafter, comma, the respondent bank filed an original application before the learned Debts Recovery Tribunal under Section 19 of the Recovery of Debts due to banks and financial institutions Act, 1993. For recovery of rupees 20 lakh 20,000, 28 lakh 20,000, 622.50. Joint land severally with pendant light and future interest thereon at the contractual rate till realization, comma, along with cost and other reliefs. Full stop. The original application was numbered and registered as OA number 245/2017. So the original application came to be decided on 17/11/2017. Holding that the respondent bank as an applicant was entitled to get recovery certificate as paid for. Full stop. The learned Debts Recovery Tribunal had thus issued a recovery certificate in favor of the applicant bank therein, that is the respondent bank hearing. Full stop. The recovery proceedings was initiated by RC case number 2695 stroke 2017. And in the process, comma, the dwelling house of the petitioners was attached by an order dated 12/10/2022. The petitioners have projected that due to failing health of the petitioner number 1, they were unable to pay the outstanding dues to the respondent bank. Full stop. What is 38 lakh proposal?
38 lakhs which including penal interest.
Where is that mentioned? Proposed to pay, you said.
Oh, certificate.
You said proposed to pay.
No, propose, no.
Because at an earlier stage, there was indeed a settlement before the RO. Certain checks were issued which bounced money. That case, we have now withdrawn in view of the payments made.
Yes.
Before the recovery officer command the petitioners proposed to pay a total amount of rupees 38 lakh in installments towards discharge of his liability, their liabilities. Full stop. After hearing the parties, the recovery officer, by his order dated 2/8/2023, page 50, I think. In his order dated 2/8/2023, recorded that CHB means certificate holder bank.
Yes.
CHB certificate holder bank.
The respondent bank as the certificate holder bank, CHB, had agreed to the proposal subject to the conditions mentioned therein. And with the further condition that the petitioners as the certificate debtors within bracket CDs would not create any encumbrance on the mortgage property until payment of the full amount of rupees 38 lakh plus interest as per recovery certificate and other charges as per his application. Page 50, and without the leave the family. For ready reference, the relevant part of the order dated 2/8/2023 of the recovery officer is extracted herein below page 50. Page to that. Page 50. Okay. How much you paid?
I paid till now 35 around 65 around 35 lakhs. More or less.
Any extension?
Yes, for 6
This
months.
settlement initially, my lord, was working and then certain checks bounced. And therefore that was cancelled. That is not pending now.
We are
That is,
anything before any proceeding before the RC annexed here?
yes, my lord.
After page 50, what happens?
Yes, my lord. In IA, I filed that last order.
Okay.
I filed the last order IA. Page, my lord. IA, page 21. This is the last order.
Subsequent to the order dated.
There is one at page 52 months.
Yes.
Yes, 52. 10/8/2023 months. Annexure Roman I. Or I.
That is
That is
different. That is previous taken over already once that property has been taken over.
Physical possession was given, taken, and then later it was returned, restored back to him when he paid 8 lakh rupees.
We are only on the amount and just,
Page 21 of the IA, my lord.
that was into, okay.
Page 21 IA.
No, page 84. On 3/4/2024, comma, the petitioners paid for more time to deposit the remaining amount of the loan. Sorry, during the subsequent period, comma, the petitioners had paid a part of the said agreed amount, full stop. On 3/4/2024, comma, the petitioners paid for more time before the recovery officer to deposit the remaining amount full stop by his order dated 3/4/2024. No, the recovery officer on 3/4/2024 passed an order, and the relevant parts of the said order are in under page 85, mark to mark. Full stop. From the order dated 3/4/2024, comma, it is demonstrated that the petitioners as the certificate debtor was directed to pay the entire amount within 3/5/2024. Full stop. Whereas Mr. Mittal and counsel for the petitioner has submitted that till 3/5/2024, comma, the petitioners had paid a substantial amount, and according to him, comma, an amount of rupees, a sum of rupees 2,70,000 has remained outstanding. Full stop. As full stop. Mr. Ganguly, learned counsel for the respondent bank, has submitted that on 3/5/2024, the petitioners as certificate debtors had appeared before the recovery officer and submitted an application seeking extension of time to repay the remaining outstanding amount. Full stop. From the order dated 3/5/2024, comma,
Sorry, my lord, the order, date of the order appears to be wrong, because the application, the order records the date as 9/5, but the order date is shown 3/5. As per my instruction, it should be 9/5.
on page 21, annex
Yes,
C.
the date in the left column is 3/5, but your lordship will see that the CD is directed to supply a copy of the application dated 9/5. So not the application
no.
date, it cannot.
Maybe wrongly
It is
recorded.
9/5, as per my.
Whatever, 3/5 it is. From the order dated 3/5/2024, comma, annexed to the interlocutory application
NSS C,
C.
21.
number 1/4/2024, comma, it is evident that the recovery officer of the debt recovery tribunal had already taken cognizance, the application submitted by the petitioners as certificate debtors for consideration by directing the certificate debtor to supply a copy of the application to the certificate holder bank. Post of the certificate holder bank, that is the respondent PNB, has been directed to file reply stroke objection upon the application filed by the petitioners as certificate debtor. Post of the recovery officer has further ordered that further has posted the application, posted the posted the next date of RC case number 2695/2017 on 23/8/2024 for filing of report by the certificate holder bank. Post of from the order dated 3/5/2024, it is evident that the recovery officer is already in season of the matter. Post of the petitioners, if agreed in any manner by the order, by the order dated 3/5/2024, they have a remedy under section 30 of the Recovery of Debts and Bankruptcy Act 1993. Is the new name?
Yes, no, that was amended in 2016.
1993. What is that new judgment? PHR or something?
Regarding this,
DRT? Strict. Now more strict. Hardly 10-15 days back. Also, as the petitioner has a alternative, efficacious and statutory remedy, this court is of the considered back view that the present petition is not entertainable and it is accordingly held. In view of non-entertainment of the petition, the interlocutory application is accordingly closed. If an appeal, otherwise he is taking note of your case, give time to them till August so that you can pay the money.
At least that, I know, my lord, the Supreme guidelines is there that not to intervene in the one-time settlement. But in
One-time settlement, yes. Biznor Arman Cooperative Bank Limited, Inal Agarwal, State Bank of India, or
but some days back, my lord,
observe that.
but
Just
some days
because 2.7 is there.
my lord, some days back, by this Honorable High Court, the Division of Constitutional Chief Justice has directed for the bank to consider the one-time settlement.
Oh, that cannot be now.
Yes, no,
Don't know. Now, when division bench is available and State Bank of India is available from the Supreme Court, 2 judgments. Shall I observe this?
no, my
Give
lord.
it. Give that. I'll observe. You are running the risk.
No, just ask him.
You are aware of this.
I know, I know.
Then
I beg your pardon, Lordship. I beg your pardon, I have some personal difficulties. I have some personal difficulties, Lordship. Item 46, matter become infructuous in view of the interim order. Lordship may close this matter.
46.
46, Lordship. On last occasion, government advocate has produced that my relief has been granted.
Infractions.
Already relief has been granted.
Release granted.
Yeah.
Okay. Mr. S.K. Goswami, Learned Counsel, you have got the copy?
Lordship.
Okay.
Last time it was given.
A Bhattacharya লিখে দিব আর এস বড়ুয়া লিখে দিব মিস্টার গোস্বামী লিখিব আগৰ অৰ্ডাৰটোতে আছে এম এছ বড়ুৱা লিখি দিব Mr. Goswami, Learned Counsel for the petition has submitted that during the pendency of the petitioner, petition, the petitioner has got the necessary relief. In such view of the matter, the petition has become infractious. In view of the above submission, taking note of the above submission made by the Learned Counsel for the parties, this petition stands closed as infractious. Let's see.
Item number 10.
Yes.
Your Lordship, on the last occasion, the Lordship had directed the respondents' authorities to take instructions, Your Lordship.
Demolition.
Demolition.
Because I have asked, because if they approach the, suppose, appellate authority, got a stay, then no point pursuing this writ petition.
Yes, I understand.
Anything, Mr. Nayak, of
Yes.
relevance?
Lordship, it's still it was still Lordship way back in the year 2020, Lordship. And no new construction has been observed. In the second phase, Lordship, one report has been given. On 16, they went for inspection, Lordship.
26 on
16, serial number 10, Lordship.
10. 16.5.
Yes.
Now, sealing is done.
Sealing is already there.
Now, anything is illegal.
It is illegal. That is why it is under.
Issue notice then.
Lordship, that illegal portion, Lordship will get at serial number 9, Lordship.
9. All right, Mr. E. Deori, Learned Counsel for the petitioner. Your neighbor?
Yes, Your Lordship.
And Mr. E. Nayak. One also Housing Urban?
Yes, 1, 2, and 3.
Standing Counsel, Housing and Urban Affairs Department, GMC, Roman N, GMDA, for the respondent number 1, 2, and 3. Full stop. The petitioner has stated that he is the owner of the adjoining plot of land, right?
Yes, Your Lordship.
He is the owner of the plot of land, adjoining to the plot of land of the respondent number 4. Full stop. It was your complaint.
Yes, sir.
As the respondent number 4 has constructed a RCC G+3 building in the said plot of land, without following the conditions laid down in the permission NOC, no objection certificate, or what does it say?
Your
NOC
Lordship,
stroke
can you
permission.
Page 38.
He made a complaint before the respondent GMDA. Full stop. After issuance of, after providing opportunity to the respondent number 4, the respondent GMDA the Chief Executive Officer of the respondent GMD had passed an order date on 13/10/2022. 13/10/2022 or what? Sorry,
Yes, Your Lordship. Page 20.
13/10/2022.
Yes, Your Lordship.
Directing the respondent number 4 to demolish the unauthorized part of the construction. Full stop. Subsequently, comma, on 13/2/2023, a similar direction has been made. Full stop. Whereas Mr. Deori, learned counsel for the petitioner, has submitted that in both the orders, comma, dated 13/10/2022 and dated 13/2/2023, comma, the respondent GMDA authorities had observed that in the event of failure on the part of the respondent number 4, demolish the unauthorized part of the construction, comma, the GMDA would proceed with the demolition, with the process of demolition of unauthorized structure or sealing of the premises of unauthorized construction. First of all, the petitioner raising a grievance that the respondent number 4 has failed to demolish the unauthorized part of the construction on his own, and after his failure, comma, the respondent GMD authorities have failed to adhere to their own direction made in the order dated 13/10/2022 and dated 13/2/2023. Post of Mr. Nayak, Learned Standing Counsel, so and so. Appearing for the respondent number 3 has submitted that last inspection was made on 16/5/2024. And it is found that the building, RCC building of the respondent number 4 is still in sealed condition. Full stop. As regards the other part of the allegation raised by the petitioner, he has submitted that he will obtain further instruction. Full stop. Issue notice returnable in 4 weeks, or returnable on so and so, as Nayak has appeared and accepted notice for 1 to 3, no formal notice, extra copies, 3 working days. The petitioner shall take steps for service of notice upon the respondent by registered AD.
96.
Within few days.
I'm deeply obliged, Your Lordship. Item 11.
Your Lordship, on the last occasion, the petitioner was called for to submit the NOC. May I ask for your permission to submit the NOC?
Mr.
Not receive the notification.
Take this, file an appeal.
Your Lordship, I
We
want to
can
say something.
provide you
No, Your
waiting
Lordship,
time 7 days.
Your Lordship, yesterday one development has taken place. GND, as you know that this matter is a sub judice, GND has again served us a notice
May I give you the copy? Yesterday evening, when the matter is sub judice and there is a speaking order of this court, why GMD is taking this kind of steps? Letter issued on 15th.
This is not coercive action.
Not coercion, but
No, everything, but just because the writ petition is filed, everything will be stalled. It is not anything congruent to, incongruent to the order. Coercive action means coercive action.
but
Just because other things may proceed. I'm not observed. This is nothing.
okay, now, but we have challenged the that order.
So I have observed already. So, and next date is fixed. I can give you 7 days bidding time to apply, to file an appeal.
To file an appeal.
Under section
Till then,
71. Section
and get an order from the appellate authority. DMDA.
I may hand over a copy, but it's
Yes, yes, sure. Because these are determination of facts, whether the NOC was in mother's name, whether he is his son, all these are to be deposed. 71. no?
71. It should be within 30 days.
And what is the date of the order?
Also, order dated is 18/3/24.
It was GMC or GMD from
Page 34.
say no, separate. $74. Appellate authority. It is exhaustive. And what is the order?
Page 34.
34.
But dated 18/3/24.
Okay. When did you file this? When did you file this writ petition? 29. Okay, he has the power to condone the delay. This writ petition is filed on 29/4. 29/4. That means today is, this can be
He can
condoned,
this can be condoned. He can give a application for condoning. Also.
right?
That can be-
Plus, I'll observe, this is to be considered under section 14 of the Limitation Act. This period he has spent
Here, yes.
before this court,
Sure.
right?
Sure.
So that
We get a chance. For it.
the district judge will not have any difficulty.
Sure.
Okay, we'll come back.
Yes.
After GMC, what a response number,
No, GMD, my lord.
GMD,
GMD. Response. 2, 3, and 4. 2, 3,
2,
4, 5.
3,
4, 5.
4,
5 only.
5 also.
5 also.
So you are fighting against your brother and sister.
Yes. Yes, yes.
Huh?
Basically, yes. The complainant is the sister.
A petition has instituted the instant petition under Article 226 of the Constitution of India to essay an order dated 18/3/2024, passed by the respondent number 4. Full stop. By the proceeding which led to the order dated 18/3/2024 was initiated on the basis of a complaint filed by the respondent number 7. Post of the complaint is with regard to construction of on the following subject matter, para 30 to page 32. Horizontal extension of the ground floor of the existing old within bracket G+1 bracket close RCC building by constructing the 80 house stock room. Full stop. By the order dated 18/3/2024, comma, the respond in the order date, the respond number 5 as observed, which is passed in exercise of the powers conferred under Section 88 of the GMD Act 1985. Comma, the respond number 5 as directed the petitioner to remove the unauthorized construction of the building, comma, allegedly constructed by the petitioner in violation of the provisions of the GMD Act 1985 and the building bylaws and the applicable building bylaws within 10 days from the date of each communication, comma, failing which it has been further observed that on the event of failure on the part of the petitioner to do so, comma, the GMD authority would proceed with the demolition of the unauthorized construction or sealing of the premises of the unauthorized construction. Full stop. In this petition, comma, the petitioner has contended that the construction was made on the basis of a no objection certificate issued earlier in the name of his mother, and as such, comma, such construction cannot be termed as unauthorized. Full stop. On the other hand, comma, the respondent the contention of the respondent GMD authorities are that the NOC was not in the name of the petitioner and the validity of the same had expired long back. Full stop. The petitioner has also raised a contention that the unauthorized construction was not made in the share of the building in that part of the RCC building where no, the unauthorized construction was made in a part which does not fall in the share of the petitioner.
Yes.
Rather, comma, the said part falls in the share of the respondent number 7 and the respondent number 8. Full stop. Where the contentions claims from the contentions from the claims made by the petitioner and the counter claims made by the respondent GMD authorities, it is evident that a number of disputed questions of fact would call for consideration. And for determination of such disputed questions of fact, a proceeding is not a proper and appropriate remedy to stop, be that as it may, well, no, not like be that as it may, like first of from the provisions of the Guwahati Metropolitan Development Authority Act 1985, it is found that the petitioner has an adequate efficacious and adequate and efficacious statutory remedy of filing an appeal against the order dated 18/3/2024. Chapter Roman 8 of the GMD Act contains section 71 to section 76. Full stop. For ready reference, section 71, section 72, and section 73 are quoted herein below. Full stop. By notification dated bearing number so dated 22/8/1996, issued under section 71 within bracket 2 of the GMD Act 1985, the state government as designated a district and session judge Kamrup Guwahati as the appellate authority to decide appeals arising out of the provisions of the GMD Act 1985 with the approval of the Guwahati High Court. Also, in such view of the matter, as the issues involved a number of disputed questions of fact which would require determination, and considering the fact that the petitioner has an efficacious and altered adequate and efficacious statutory remedy in the form of an appeal, this petition is not entitled, reserving the liberty to the petitioner to prefer an appeal under the GMD Act before the appellate authority, designated appellate authority. Full stop. Para Mr. So-and-so learned counsel for the petition has submitted that as per section 72 within bracket 2 of the GMD Act 1985, an appeal is to be prepared within a month from the date of the order appealed against. Full stop. And the said period has already expired. Full stop. Para. The present petition was instituted on 29/4/2024. Full stop. নালাগে এনেকে লিখক এইটো নেক্সট টাইম লিখিব under subsection 2 of section 72 comma the appellate authority has the discretion to condone any delay in filing appeal for sufficient reasons. Full stop. The instant petition was filed on so and so date. Full stop. The petitioner, while preparing the appeal, will also be at liberty to file an application seeking condonation of delay, seeking condonation of the period delay which could occur in preparing the appeal. Full stop. It is observed that the period, the appellate authority shall consider the period spent by the petitioner in pursuing the present writ petition from 29/3/2024 till date in the light of the provisions contained in section 14 of the Limitation Act of 1963. First up, for ends of justice, comma, this court further observes that if the petition prefers such an appeal within a period of 15 days,
15 days.
from today, comma, the appellate authority shall consider the prayer for condonation of delay in an expeditious manner for the purpose of admitting the appeal and full stop. It is submitted by Mr. Bora, learned standing of GMD, has submitted that has fairly submitted that there shall not be any, there would not be any coercive action on the respondent GMD office for a period of 15 days from today.
For how many days?
15 days.
Make it 21 days.
Huh?
For 21 days, at least.
But
21 days, at least.
okay, 21 days.
21.
Yes. And Mr. Dideka. Yes,
I have seen, Milord, only one.
service
thing.
rules
Yes,
says what?
Milord, as per this notification,
Hmm.
2018 draft service rule has been asked to be followed for the post of process server. There is an element of direct recruitment for the post of process server. It will be
Okay, I will issue notice at this stage.
subject to the outcome, I think that will.
Appointment will be subject to the
Yes,
outcome
yes,
since he has already been appointed.
Yes, my lord. Initially, I also thought, my lord, what is this contractual appointee? In
How does it, just for the purpose of my knowledge,
Yes. I have only given the relevant portion of the rule. If your lordships kindly see, schedule B, process server, there is direct recruitment and promotion. Element of direct recruitment is there. So at this stage, I don't know, my lord, what
Hmm.
was actually decided there.
resolution will be of relevance.
Yes. in that event, the advertisement may be wrong, because in the advertisement, they say eligible grade 4 employees.
Okay, we'll. And Mr. Das, please, you please also
Yes.
apprise us that
Yes.
how draft rules can be followed,
Yes,
because that issue will be relevant for others also.
yes,
What are the authorities? I know one Bimola.
yes.
One Bimola I know.
Milord, I read, Milord, if it is the intention of the government or the authorities that will follow the draft rule, then Milord, draft rule can be followed. That is one. Second thing is that Milord, if there is any vacuum in the rule, original rule, and it has been like in our other case, copyist and typist, because there was no provision in 87 rule. So there was a conscious decision of this honorable court to follow draft rule, that particular provision. So in that event, it can be followed.
You appear for whom?
I'll appear for respondent number 2 and 3.
MSS Borua, Learned Junior Government Advocate Assam for the respondent number 1, Mr. H.K. Das, Learned Standing Council Junior, Standing Council, Guwahati High Court for the respondent number 2 and 3. Full stop. How many petitioners?
2 Lordship.
2 petitioners.
You are employed or? Okay.
We are employed.
The 2 petitioners are presently employed as grade 4 within bracket beyond in the establishment of the respondent number 2 having about 7 years of experience. Full stop. The petitioners responded to an advertisement
Page 17.
dated 2/1/2024 within bracket Annex 1, whereby applications were invited from intending eligible grade 4 employees working in the establishment of the respondent number 2, having minimum educational qualification of graduation for filling up a vacancy in the post of clerical stroke process server. Full stop. In the selection process initiated pursuant to the advertisement dated 2/1/2024, the respondent number 5. Number 4, who was serving as a driver within bracket contractual in the establishment of the respondent number 2 came to be appointed in the vacant post of the process server by an order dated 21/3/2024 passed by the respondent number 2. Full stop. Para Mr. Dekal, Learned Counsel for the petition, has contended that the petitioner or respondent number 4 by no stretch can be made eligible as a grade 4 employee in the establishment of the respondent number 2, as at the time of his selection and appointment, he was only serving in contractual capacity.
Yes, Lordship.
That is your ground?
Yes, Lordship.
Okay. Issue notice. Mr. But then grade 4 employee, contractual may not be.
Where I am saying, so there is an element of direct recruitment. I don't know, Milord,
Then
whether
you
they
cannot go beyond
all,
advertised.
yes. There, my lord, there is conflict.
Leave grade 4 employee, grade 4 contractual cannot be.
Exactly.
He should be a member of the service. Issue notice returnable on so and so.
21-6.
Having regard to the so and so, the petitioner shall take steps for service of notice by liquidating. Upon the response number 4 by registered post with AD within 3 working days. Having regard to the projections made on behalf of the petitioner that the respondent number 4 was not eligible to participate in the selection process as a grade 4 employee in the establishment of the respondent number 2, and his appointment is partially illegal, it is observed that the appointment of the petitioner would be subject to the outcome of the repetition.
Respondent, my lord, appointment of
Respondent
respondent.
Number 4.
Highly obliged.
No, please listen. Yes, madam.
May I present lordship? My lord, my signature legs kindly pass on the madam. Yes.
What is the issue?
My lord, this
Very
petition
mal-
number 1 to 60 are the
Many
purchasers of
petitioners, how many petitioners? 61.
61. A round of litigation had culminated in the order
We
dated.
can put a short notice. I think you are similarly situated.
Yes,
My lord,
You claim to be similarly
yes,
situated.
Your Lord.
my lord, she needs to submit something, my
Huh?
lord. She's coming only.
Okay, coming. Okay.
Mid lordship. The petitioner in this case is challenging an order passed by the government by which, my lord, the application filed by the petitioner for extension of the validity of the eligibility certificate was rejected. Now, my lord, in fact, earlier the petitioner filed a writ petition, my lord, on the ground that the applications were kept pending, but when the affidavit of opposition was filed, the petitioner came to know that it was rejected, and thereby the petitioner withdrew the earlier writ petition and filed a fresh with the liberty of taken by the court. Now, at this stage, my lord, I think only notice there is no interim prayer. The impugned order, you also find at page, you must say.
No specific interim prayer.
My lord,
No specific interim prayer.
no interim prayer.
Heard Dr. A. Sarah. Learned senior counsel.
Go to page of it, similar.
Assisted by Mr. Yes,
लिख दिया ना आगे।
A.J. Soikia. S.J. Soikia.
तो लिख दिया ना item
Learned counsel for the application.
ऊपर item लिख दिया।
Mr. B. Chaudhary. You respond number 1 also?
On, lordship, respondent
Yes,
number
Gaurav.
will appear.
Learned
2, 3 and
senior government advocate
five.
Assam for the respondent number 1, and Mr. B. Chaudhary. Learned standing counsel finance and taxation department.
Yes.
For the respondent number 2,
2,
3,
5.
4, and 5. Full stop. In this repetition, the petitioner has challenged the legality and validity of the Assam industries within bracket tax reimbursement for eligible units bracket close bracket again amendment bracket close scheme 2020 and a communication bearing number so and so dated 10/2/2021. Prayer portion was issued under the hand of the respondent number 3.
As well as, my lord,
And panel 1 to 3 corridor. 2 second and another a communication dated 3/3/2021.
Well,
issued under the hand of the respondent number 2. Full stop. The petitioner has also sought for a direction to the respondent authorities to consider the case of the petitioner for extension of the period of eligibility as per the provisions of the Assam Industries within bracket tax reimbursement for eligible units bracket close scheme, 2017. Okay. Issue notice returnable on so and so date. As appeared accepted, no formal notice, extra copies within 3 working days.
Well, item number 22,
Respondents are same,
same,
challenges are same,
same.
communication,
Well,
communication data same.
22, 23, 24 and 25.
22,
23, 24, 25.
23, 20, 24 also?
24, 25. Total 5 cases, below. But then I can't. Item 15.
My pleasure, Lordship. This restriction is preferred because there is a delay in completion the investigation of DIFU PS case number 11422. The petitioner herein is the registered owner of 2 vehicles. One is a dumper and another is a JCB. Annexure 1A is the.
I have seen your synopsis.
Yes, Your Lordship.
FR was submitted.
Yes, Your Lordship. Thereafter, we file an objection before the CZM.
Right.
And the CZM directed to make a further investigation by appointing an efficient IO. But till date, nothing has been done. I have made an representation before the Director General of Courts also.
Where is the question of entering English?
Lordship,
Take note of one. Vishnu Kumar Tiwari. Come back at 2. Vishnu Kumar Tiwari. Come back at 2.
yes, sir.
Huh? Undu timing. Huh? Oh.
Finding of the item number 13.
Yes, madam. Bora.
I'm sorry, my lord. I was on legs, my lord.
We can put short notice.
Lordship. In fact, Lordship, in the earlier round of litigation, I have filed by petitioner and Lord, this honorable court is observed one thing, my lord.
What? You are claiming to be similarly situated.
Yes, Your Lordship.
And in the earlier round of,
The other petitioners got the relief.
yes, 1 to 9
That
earlier,
court,
9 of them had got relief.
Which one? Which paragraph?
Lordship, may I read, my lord? This court had allowed the petition, Lordship, 6 paragraph 6, sorry.
So you get the report.
Yes, Lordship, because they have paid for 678 vehicles. In fact, in page 42, my lord may kindly have a look.
Here we have how many petitioners?
69, that's why I'm Lordship pointed out.
6,
60,
60.
60 Lordship and JB Energy. 66.
Right.
Yes. And all are not before this honorable court. Only for who are before this honorable court, I will verify, Lordship.
So what is the prayer?
Prayer for 678,
It cannot be.
Lordship.
Very well, Lord.
You represent your own cause.
Yes.
Very well. But my lord, my learned friend had earlier filed an affidavit.
I will file in case
uh,
I will file.
showing the
If
genuineness
the
of the-
petitioners themselves are not before this court, how can we?
and most of the
Then. Now let us
Person
see your
name-
prayer.
are there.
678.
Lordship. In fact, Lordship, I just want to,
60 means 60.
yes,
Very well.
We'll record that.
my lord. Lordship, another thing, page 42, my lord.
You take your instruction regarding these 60 petitioners.
I will get instruction. Page 42, my lord, paragraph 6. Here, this honorable court, order has been overwritten. They have stated, Lordship, paragraph 6. As regard the genuineness of the passage, the district transfer officer has filed an affidavit in opposition, which it has been stated that the passage is in overwritten all 678 vehicles in my petition.
Oh, it is removed.
Oh, Lordship, I am surprised, Lordship, this honorable High Court order. This
It
is,
is not here.
yeah.
Okay.
My lord. Short notice, my lord,
MS.
may issue.
Huh?
May
Short
I
notice.
pray, Lordship, that the records of the earlier round of litigation, we had filed the purchaser's list and the compilation was made. So
So
may I
you,
pray the record-
is 60, is there any compilation in your petition or not?
No, my lord,
Huh?
but it was
The
filed
vehicle
earlier.
number or whatever?
Earlier it was filed.
No, make a,
It's there in the.
and make a list, give it to me.
very-
I'll
Sure,
set
My lord,
these specific vehicles,
Okay.
details and genuineness would be
Yes.
verified.
my lord,
I'll do.
We issue notice today.
my lord.
If you undertake that
Yeah.
the vehicles purchased by the petition number 1 to 60
Lordship,
will be provided to MS Bora by Monday,
Lordship. After I will get the instruction and file it.
right? Third, MSB Chaudhary. Learned counsel for the petitioners and MS Bora.
And for 1, 2, and 5, my lord,
Learned standing counsel,
transport,
Transport Department for the respondent number 1, 2,
and 5.
and 5. MS S. Borua. Learned Junior Government Advocate Assam for the respondent number 6. Now what about 3 and 4 then?
Notice may go, Lordship.
Notice
Insurance
go.
company.
These are Guwahati.
Earlier occasion they have appeared.
Dusty you can do?
Yes, yes. Lordship.
Then we put it on a, after 3 weeks.
My lord,
The petition number 1 to petition number 60 have claimed that they are similarly situated with the petition number 1 to 9 in the repetition, WBC number 5271/2020 and are entitled to similar relief as have been granted to the petitioner number 1 to 9 in the repetition, WBC number 5271/2020 in an order dated 12/9/2020 passed in a interlocutory application IA civil number 2641/2022 filed in connection with that petition. Right?
my lord.
Full stop. MS Chaudhary has submitted that though in the prayer portion,
Lordship.
direction has been sought for to accept the registration fee of 678 number of two-wheeler vehicles, the said prayer may be restricted to the petition number 1 to 60 only. Full stop. MS Chaudhary has further submitted that details of the vehicles purchased by the petition number 1 to 60 will be handed over to MS Bora in a tabular form by Monday.
Lordship.
Full stop. MS Bora has submitted that Standing Council Transport Department has submitted that in the event of the details of the vehicles purchased by the petition number 1 to 60 are furnished, comma, there will be endeavor to verify
The genuineness,
Lordship.
genuineness of the purchase.
genuineness of the purchases made by the petition number 1 to 16 and the outcome of such verification will be placed before this court. Issue notice returnable in 4 weeks. 3 weeks. One arrow,
1, 2, and 5, Lordship, I am saying.
1. Okay, MD Bora, 1, 2,
And 5, my
and
lord.
5. As Borua, 6.
Six.
No formal notice. The petitioner shall take steps for service of notice upon the respond number 3 and the respond number 4 by registered post secretary. Post of as paid for, comma, the petitioners are also allowed to take steps for service of notice upon the respond number 3 and the respond number 4 by way of just the compliance affidavit. Both are from Guwahati.
May I pray for a date, Lordship?
46.
Deeply obliged, my lord.
Item 16.
Wait, please, my lord. My lords, I'm appearing online for the petitioner.
Yes.
My lord, this is a writ petition by which, my lord, the petitioners are claiming, my lord, a mandamus for refund of, my lord, entry tax which was paid in advance. My lord, it was a deposit made. Petitioner is a, my lord, is a logistics service provider to online companies. In the state of Assam, my lord, a special procedure was, my lord, made that you can pay in advance and keep it in deposit, entry tax, and as you keep on bringing in goods for the purpose of delivery through the e-commerce platforms of company, you can utilize that deposit. Now, my lord, in 2017, as your lordships know, entry tax, VAT, etc. were, my lord, repealed and GST came in. So the act stood repealed, and my lord, there is no demand to the extent of 8 crores and 28 lakhs. My lord, 46,495. My lord, we've placed that chart at page 16 of the writ petition, if your lordships are pleased to have. That, my lord, this chart gives the details of what was deposited by us in advance. If your lordship sees column 3, the total amount was 17 crores. Row 3, my lord, I'm so sorry. Row 3, 17 crores 40 lakh 5,273 was deposited, of which the utilization towards liabilities was 11 crores 97 lakhs and odd. And there were goods which were returned, so the liability diminished. And ultimately, the net liability was only 9 crores 11 lakhs 18,778 according to the returns filed. So what, my lord, happened was that 8 crores 28 lakhs, which we had deposited in advance, is an excess. And after the repeal of the act, there is no possibility of any demand any which way. And, my lord, what happened is that my lord, we've filed several representations to the respondents saying, please return this amount because this was paid in advance and there are no liabilities against this. But there is no communication received from them at all. This has caused, my lord, the filing of the present writ petition.
Sir, notice, my lord, only prayer is for refund.
Okay. Mr.
T.
Mr.
Gulati, senior.
I'm Tarun Gulati, my lord. Senior.
Tarun Gulati.
Yes,
Senior-
my lord.
Learned senior counsel. In virtual mode, assisted by Mr. S. Chettiya. Learned counsel for the petitioner. And Mr. B. Gugui. Learned standing counsel, finance and taxation department for all the respondents. Full stop. In this writ petition, comma, the petition has sought for a direction to the respondent authorities to refund an amount of rupees, the sum of rupees 8 crore 28 lakh 46,495 along with applicable interest on the ground that the said sum on the said sum is liable to be refunded, which the petitioner had deposited as advance NP tax. First one. Issue notice returnable in 4 weeks. As Mr. So-and-so has appeared accepted notice on behalf of all the respondents, no issuance of formal notice stands dispensed with. Mr. Chetia, Learned Counsel for the petitioner, shall furnish repeat number of extra copies of petition along with annexes to Mr. Gogoi, Standing Counsel Finance and Taxation Department within 3 working days promptly.
Lord, may I request just for one observation, if your lordship pleases, that if in the meantime they were to, my lord, pass a refund order, at least the pendency of the writ should not come in the way of that.
Having regard to the issue raised in this petition, it is observed that the pendency of the petition shall not be a bar for the respondent authorities to consider the claim of the petitioner in accordance with law.
Deeply obliged. Deeply obliged.
17.
My lord, as my senior is on lecture code 17, kindly matter may be adjourned for the day.
Day.
I have no objection.
What is your case?
In this case, actually, basically, the petitioner has challenged the action of the official liquidator appointed by the Honorable Calcutta High Court, my lord, in a winding proceeding, my lord. So that this petition will be maintainable before this Honorable Court, my lord, that needs to be considered by your lordship, my lord.
Oh, something, some of the process. What is your prayer? Who is he?
My lord,
Who is he?
state
He is claimed to be the owner of this, my lord.
Anything?
My lord.
Any document? You satisfy me on the whether you are a person aggrieved on the next day.
my lord.
Don't think he is a person aggrieved. MS
S. Musahari.
S. Musahari, Learned Counsel for the petitioner, and Mr. N.C. Das, Learned Senior Counsel, assisted by MS T. Bushaw, Learned
J. my lord, J.
J.
Jury.
Bushaw, Learned Counsel.
For respond number
Respond number 1.
1, 2, and 3, my lord. Only 2, only there will be some difficulty.
Cannot be, by some name is appearing.
My lord, that is the matter. He has already
3.
he has already retired, my lord.
Full stop. After having gone through the averments, statements and averments made in the petition, and the documents annexed there to the petitioner has to satisfy as to whether he is a person, quote unquote, aggrieved on the prayer of MS Musahari, Learned Counsel for the petitioner, release the case on.
Next week, any date, my lord.
You have to satisfy
My
you
lord.
are a person aggrieved. If you are not related to that company, how can you? This is very vague term, contributory.
Contributory, my lord. Obliged, your lordship.
Obliged.
4, 5.
Item 18. May it please your lordship, I'm challenging the order passed by the ombudsman against us, lordship.
Is it permissible for the insurance company?
Lordship,
Ah.
there's a judgment. Yes, lordship.
You answered this question.
Yes, there is a main prime question, lordship.
Yes. Insurance
Recently, lordship, Bombay High
Ombudsman
Court
scheme.
passed a order.
Ombudsman scheme.
Yes, lordship.
Where is the ombudsman scheme? Insurance sector asil, no? Asani insurance sector. I think there is a bar. Is it not?
No, explain that is
Earlier,
yes.
there was a bar.
It is not.
You have
exactly-
set up the scheme.
Yes, lordship.
You have set up the office
Yes, lordship.
for early disposal.
Yes, lordship.
Again,
Yes,
You will
I am-
challenge.
I am,
I think
filing-
maintainability question have been gone into by different high courts.
Yes, Lord, sir. Recently, the Bombay High Court has gone into it, and Bombay High Court has given various, in reference to various judgments, it has held that this is a quasi-judicial setup. So that can be changed under either Article under 226 or under 227. I've got a judgment. Lord, sir.
Thing in the scheme perhaps where it says it is final. 17,
17 years. Lord, sir.
8.
No, 17 years. That has been there. That has been there. But I'm filing this case, Lordship, on basis of the strength.
This open,
Yes, Lord, sir.
17, 8.
But sir, this judgment can be taken into consideration.
We'll keep this open. On the returnable date, you'll satisfy. Third, Mr. S.M. Roman, Direct Counsel for the petitioner. First up, in this petition instituted under Article 226 of the Constitution of India, comma, the petitioner, comma, and insurance and insurer governed by the provisions of the Insurance Regulatory and Development Authority Act 1999, comma, has challenged. Where is the award?
Lordship, Annex 3, page 28.
Has challenged an award dated
6/2/20 to 24.
2024,
24.
passed by the Insurance Ombudsman, comma, Guwahati, in complaint reference number GUW-H-0-0-2324-0205, instituted on the basis of a complaint lodged by the respondent number 1 after repudiation of his claim by the petitioner. Full stop. Where issue notice returnable in court. The insurance ombudsman is appointed under the Insurance Ombudsman Rules, comma, 2017, comma, framed in exercise of the powers here we ask. Conferred under Section 24 of the IRDA Act 1999. Full stop. As per Clause 8, Subclause 8 of Clause 17 of the Insurance Ombudsman Rules, comma, 2017, comma, the award of Insurance Ombudsman shall be binding on the insurers. Full stop. In view of such existence of such clause, comma, the issue of maintainability of the repetition is kept open for consideration at the appropriate stage.
So till then, Lordship, the award may can be state, Lordship. Option of the award may can be state.
Ombudsman does not have any executive power.
It doesn't have an executive order, but we need to actually comply with the order. That is the requirement. So since
Now, certiorari jurisdiction, this ombudsman has made the findings on the basis of some materials.
Yes.
And it does not appear to be perverse. So certiorari jurisdiction, the prayer for interim relief will be considered after appearance of the respondent number 1. Steps by registered post. You have made the insurance ombudsman party or register or somebody else?
No, no, well, this ombudsman lordship. Although we have made him the party, but notice may not be issued to
Of the respondent number 1 of the issue. The notice is not issued. Notice, comma, at this stage is not issued to the respondent number 2.
compliance lordship.
এখন দিব পাৰে।
Item 19.
Kindly pass over the matter for time being.
Time being.
Item number 20.
Please, Your Lordship. My lord, this is regarding illegal construction of third floor and fourth floor and irregularities in the setback.
Finding reached already or not reached? Or you have lost complaint?
My lord?
Any finding has been reached already?
Yes,
by-
my lord. Yes,
Huh?
I will take your lordship to the RTA application, which your lordship will find at page 54.
Yes, 54.
Question number 5.
5.
Has the authority allowed so-and-so to construct third and fourth floor after issuing them regulation certificate by so-and-so 23rd of August 23 for G+2 building? And question number 10, is any inspection report prepared by the engineer for third and fourth floor of the building? Your lordship will find the answer page 57. It starts from 56.
5 no.
No. 10 no.
You are neighbor?
I am a neighbor. I'm the northern side boundary.
Yes, Mr. Ora?
Lordship issue notice. My lord, in fact, the construction, I have given the photographs. The last page, my lord. Last page, page 79. Without any permission, they have constructed up to fourth floor.
Okay, but
last
consider on the basis of otherwise, Mr. Bora, you can obtain instructions so far as interim period is concerned. Then we will not issue notice at this stage. Put it on after 7 days.
My lord.
If there is no permission for third and fourth,
Yes, my lord.
then we can, otherwise it will be expired.
Lord.
And situation can be restored back by demolition.
My lord, that.
That is an issue also. So we should not pass because otherwise just at your instance, suppose
Well, that is true.
it is stopped. And you,
The GMC as well as the GMPA.
Where is the private?
simply say
party
as the whether the respond number
1 and
5 has obtained any instruction for construction of third and fourth floor of the
Yes.
undergoing under construction building.
My lord. That will
We'll
do.
take instruction. Thereafter we'll decide about the interim period.
My lord.
Third, Mr. Edhor, learned counsel for the petitioner, and Mr. Asbora, learned standing counsel, GMT and GMD for the respondent number 1 and 2.
Only GMT one.
Huh? GMC is also there.
GMT.
1 is my party.
GMC.
It is the case of the petitioner that he is the owner of a plot of land which is adjacent to the plot of land owned by the respondent. Who is the owner?
4 and 5.
Owned by the respondent number 4 and 5. Full stop. It is the case of the petitioner that the respondent number 4 and 5 along with respondent number 3.
He is the builder.
Respondent number 3 is undertaking construction of a multi-story RCC building in the adjacent plot without any no objection certificate stroke permission to construct the third and fourth floor. Post office. It is further about that the response number 3, 4, and 5 have already completed. What is that?
Superstructure.
Superstructure of the third and fourth floor of the under construction RCC building. First, Mr. Bora, at this stage, Mr. Bora, staying down GMC and GMD has sought listing of the case on next Friday.
Well, it is on 20,
Next Friday or Monday?
not on 27, madam.
On 27th, 2020.
Can it be on 28th, 28th or 29th?
29,
Madam,
29, 5, 2024, in order to obtain necessary instructions as regards NOC stroke permission.
Provide me a copy of the petition. My friend will.
Mr. Dhor and a copy of the petition, so furnish a copy of the petition and will be annexed to Mr. Bora during the course of the day
Madam,
and post of place the case accordingly on Swift.
obliged.
The 19.
One, 19.
Item 19.
It's,
Item 19 of
oh, sorry.
May it please your lordship.
Hmm.
In this matter, we are challenging notification extending time limit for issuance of order under section 168 8A of CGST Act. Lordship, this section provides power to the concerned authority to extend time limit.
Mr. Kal,
These are the similar.
you once raised an issue that this should be, how this is to be read.
Yes. Because power is there with the authority.
What are the other orders passed by the other courts?
Yes, Lord, they have similar order.
Oh.
Page 72.
I'm asking the question only for the purpose that whether those orders were passed by single bench or division bench.
Single.
Single bench.
Single.
The orders, no, not by this court.
Oh, earlier,
Other high courts.
the high courts, probably in one case, probably division bench, other, our high court in Itanagar bench.
No, don't say about our high court. What are the orders of the
Mostly
other high courts?
Mostly single,
Mostly single bench or division bench?
single.
Hmm?
Single. Here, next case.
You have an next here.
Yes, Lordship,
Any orders? Those which you have referred to that
it's number
you have in
7.
Haryana, Madras, Gujarat, Allahabad.
No, Lordship.
That has not been annexed yet.
No,
Do you have the
Lordship. We don't have,
Huh?
I have
right now,
copy
we don't have.
I have copy
Lordship.
with me.
Hmm?
I have copy of different high courts.
Hmm.
Today,
Have you checked?
Lordship,
Because though I was of the view
not.
that notification issued in an exercise of a statutory power
Yes.
may be challenged in a petition before a single bench. Perhaps the view of the Supreme Court is that it is part of the statute.
Initially, but our high court, high court rule says that only the main legislation and subordinate legislation regarding notification. Nothing is
But
there.
interpretation of Supreme Court,
Yes, that may be.
interpretation of the Supreme Court is that this is a statutory notification, this is part of the statute.
But see, the view of court number 17 was different. When any notification is challenged, that matter should go before the division bench.
Now, I'm not sticking to that observation because might be it is a case, this has to be read as part of the statute.
Yes, Lordship.
I think that is the interpretation of Supreme Court. Take a call.
Lordship, I'll.
Because otherwise the issue could be that assuming a jurisdiction
Lordship.
by the single bench,
Hmm.
which it does not have.
Conformity with the more direct. Right.
Have you understood that?
Yes, yes.
It is part of the statute. It is to be read as part of the statute, then it is to be. Your name, please.
B Sharma.
Be sure. Learned counsel for the petition. Response number 1, K. Pooper. Central Government Council for the response number 1,
Input 2 and 3.
Jessica Lannex, Training Council, CGST. For the response number 1, 2,
No, 2 and 3.
2 and 3, Mr. B. Chaudhary. Standing Council, Finance and Taxation Department, Assam, for the response number 4 and 5. Let's stop. Okay. Page 60, huh? 60. In this edition, instituted under Article 226 of the Constitution of India, the petitioner has entirely assailed Roman 1 notification number, what are the notification number 09/2023 prior to their central text dated 31/3/2023. Roman 2 notification number 56/2023. Their central text dated 28/12/2023. And an order in original. Order in original. Order in original.
Lordship.
It is, yes.
Final order has been.
Order in original dated 26/4/2024. Passed by the respondent of 5 under section 73 of the CGST stroke SGST Act, 2017. So stop. The notifications, dated 31/3/2023 and dated 28/12/2023 are issued in exercise of powers conferred by section 168A of the Central Goods and Services Tax Act, 2017, and other identical provisions of the Integrated Goods and Services Tax Act 2017 and the Union Territory Goods and Services Tax Act, 2017. Full stop. By exercising the said power, the time limit specified under subsection 10 of section 73 of the CGST Act for issuance of an order under subsection 9 of section 73 for recovery of tax not paid or short paid or of input tax credit wrongly availed or utilized relating to inter alia for the period, where are the notifications?
Lordship 1819 for the financial.
18?
2018.
Page.
Okay, Lordship, page number 59, order annexure L.
Notifications.
Notification page 43.
Notification page 43. Notification 09/2023, page 43.
You are interested in which year?
1819.
For the final, for the inter to the period, financial year 2019. has been extended up to 31/3/2024, and for the financial year 2019-2020 has been extended up to. But there is a subsequent notification.
Lordship, 56 of 2023, notification
Page.
number 52.
So 52 is more important.
Yes, sir.
Yes, Lordship.
For the financial year, 2018-2019 has been extended up to
30th April.
30/04/2024, and for the financial year 2019-2020 has been extended up to 31/8/2024. Full stop. It is on the basis of the said notifications, a demand cum show cause notice was issued to the petitioner, and thereafter, the order in original dated 26/4/2024 has been passed determining what amount not aware.
Lordship, page 62. One crore 60 lakhs 88,000.
Determining an amount for recovery under section 73 of the CGST Act, 2017, and corresponding similar provisions in the SGST Act, 2017, as ineligible input tax credit.
Yes.
Or what?
Yes. Yes, Lordship. Ineligible.
Input tax credit. Post of. It is the contention of the petitioner that after the year 2012, there was no COVID-19 pandemic in existence. Full stop. Attention has been drawn to the order dated 10/1/2022, passed by the Honorable Supreme Court of India in suo motu petition now C number 3 of 2020, to contend that the Honorable Supreme Court of India, after taking all the factors into account, had extended the period of limitation only up to 28/2/2022. Full stop. Thus, there was no occasion for the GST Council, GST Code, council to take resort to the factor of COVID-19 pandemic in order to extend the time limit under subsection 10 of section 73 of the CGST Act, 2017. Those as a para 4 to the devote. Para 5 to the devote. Para 6 returnable on 7 to the devote. 8 to the devote. After Logore, 8 to the devote, and this court. This court will dedicate. Providing interim reliefs to the notices stroke SSS. 902 number as to this court dedicate. It is observed that the as an order in original has already been passed, and taking note of the fact that similar issues are being examined by various courts of the country, this court is inclined to provide that till further orders of this court, a recovery of the amount assessed against the petitioner shall not be enforced.
Lordship, there are two similar matter, item 21 and 29.
So, Parties are same. Notification was same. Order in original date
Lordship, in
is
21.
there.
Yes,
or no?
Lordship, item
Oh.
21, order in original dated 30th
Huh?
30th 4, 2024.
No, you are in 21. Where is the order in original?
Page 52, Lordship, annexure
52.
52,
Okay, date,
30th 4, 2024.
same date.
Lordship, yes, Lordship,
Same date like the earlier one.
no, Lordship. There was 24 4,
Earlier
26 4, 26 4,
To
2024.
34. Same again. In the third one,
Lordship.
18/4.
parties are same.
Parties are same, yes. Parties,
Notification and the challenge same. Order in original 18/4.
18/4.
Response number 5. In all, response number 5.
Yes, Lordship.
Extra copies 3 of this date same, returnable date.
Deeply obliged, Lordship.
Number 26.
May it please your lordship.
Hmm.
If I'm before your lordship against the blacklisting order by the respondent, your lordship, the sole respondent, your lordship.
Why that?
The impugn order, your lordship.
Hmm?
No, two. You can rush. It is as page 38, your lordship. Addressed to me, your lordship.
Hmm. Which part?
Page 39, your lordship. The third paragraph,
Hmm.
fourth paragraph. After review of the,
Debarred
yes,
Banned.
debarred.
For
Yes.
participation
So debarred from participation
for a period of 5 years.
5 years, your lordship. Now, the fact of the case is, your lordship, the petitioner has participated
You
in,
can only issue notice at this stage.
your lordship, I need an interim order, your lordship. I will satisfy your lordship. Why this is, apparently this is illegal. First and foremost, they cannot
Let
Permit
them
for
come,
5 years.
Mr. Sharma, this is a final order. An interim order to the extent that as it is amount, if it amounts to final order, that kind of order should not be passed.
That I understand, your lordship.
This is the clear cut.
I understand.
Staying this order means revival of your.
Another prayer is regarding return of the security deposit, your lordship. That's why I'm saying, your lordship. There are two prayers of the petition. One is refund. On regarding that prayer, I'm not pressing anything, your lordship. That will amount to a final order. Whether I'm entitled for refund of
Both the orders, both the orders almost the final order.
Lordship, regarding security deposit, I'm not pressing anything. Only thing is that
This staying of this order means what? Tell me.
it will,
What is the consequence of staying this order?
that means the debarment will be stayed. The blacklisting will be stayed.
Then
That I understand, your lordship. But
what
what?
it would amount to?
It amount to give
And whether this kind of order is permissible as an interim order.
that I understand, your lordship. Only in these peculiar circumstances, if your lordship
You can
give me
make
just
it returnable on a fixed date.
apparently on the face of it, it is illegal, your lordship. That is
You
why.
have to reject your interim prayer.
Lordship, because I am apprehending, it has already been done. Other government contexts that I have been pursuing as of now, because I was not even aware that I was debarred. So what happened, your lordship? I have participated in several other tender process thereafter, and fortunately, I also got work order from several other government departments. While participating in such contracts, your lordship, I have never stated that I was debarred because I was not aware. They have never communicated this. This is my case, your lordship. Now, what happened in one case already by a different department, that is Assam Police Housing Limited, they have again debarred me.
Sharma, right? Your debarment order is of 29/3/2022.
24/3/2022. Yes.
Huh?
Yes, your lordship. I came to know about it this last month only. For 2 years, I was not even aware that this order was passed.
Those are to be examined in the due course of
Yes, your lordship. In the meantime, what happened? If your lordship may kindly permit me to submit.
There are ripple effect.
Yes, your lordship.
There used to be ripple effect.
Yeah, because I'm innocent, your lordship. I didn't know.
Right, but innocence is to be proved after.
Yes,
Appearance of the party.
from the record of the
Mr.
can be proved today
Staying
itself.
at this stage of this order of debarment for 5 years
Yes, Your Lordship.
by an interim order.
Your Lordship, there will not be no inconvenience will be caused to them. I can give an undertaking that I'll never participate in any tenders floated by them.
Consider your interim period.
Lordship, okay. Yes, Your Lordship, what happened actually, Your Lordship?
But also you have to run the risk of observation.
Lordship, if Your Lordship may permit me to submit only two things. First and foremost, only two things. Your Lordship, if it's not satisfied, then it will remain open for.
That will not open. After hearing, I will not keep it anything pending. I will make up my observation.
Only one small thing.
I'm making it clear. I have said that we'll expedite the process. But if I have to hear, I have given the.
Your Lordship, then may kindly accommodate me for only one thing, one statutory general financial rules I want to show Your Lordship. That itself, if I'm permissible for that ground only, other I'm not pressing. The matter of facts I'm not pressing. Only law, Your Lordship. Only law, Your Lordship. May kindly peruse Rule 151 of general financial rules. This is regarding debarment from bidding, Your Lordship. Rule 151, sub-rule.
The order of debarment.
Yes, Your Lordship. At page 38, Your Lordship.
Page. Let me read it first then.
Yes, Your Lordship.
Have you annexed those work completion certificate and LOA here?
My reply will clarify at page 35, Your Lordship. At page
Have you annexed
no.
those work completion certificate and LOA?
Police, Your Lordship. That
LOA here.
Not in this, but
Then
I can produce it.
How can we?
Monday I can produce if Your Lordship wants to see, Your Lordship. My reply will clarify at page 35.
No reply. We have to look at the document also to have derive a primary satisfaction, because the allegation is that
False document.
all these documents were
False
forged.
document. False document. At page 30
Documents.
At page 35, my reply will clarify, Your Lordship.
Though we cannot determine, but we can have a look at least.
Yes, definitely. I can produce that on Monday because I have to case file this hurriedly. The only reason, Your Lordship, I am apprehending that in 3-4 more other where the ongoing works are going on, they might debar me again. Because I have already annexed one at page.
Right.
Page
Debarment
36.
order has ripple effect.
Yes, at page 36.
That
huge amount of money, Your Lordship, and entire my career will be ruined, Your Lordship.
right. That is why I say that
At page 36,
the process, but okay.
The ripple effect is evident from page 36.
Calculus. Okay. On the prayer of Mr. P.K. Sharma, Learned Counsel for the petition. Release the case on Monday.
Monday, Your Lordship. Obliged, Lordship.
May I please, Your Lordship? Your petition, my lord, pertaining to my lord.
Excellency.
Yes, my lord.
Mr.
T. Sheikh, my lord.
P. Sheikh. Yes, Mr. Demolition notice.
But
Heard Mr. T. Sheikh, Learned Counsel for the application.
1428, Lordship.
And Goswami. Junior Government. So 1,
428.
and 2, and 428. Arborua. Oh, Mr. Aborasite. Revenue disaster 1. RM Borua. Representing Bigwood Finance Department. 3. The petitioner as claiming herself as the next of kin of one late Odit Ali alias Aziz Ali, who was her son, Samar, has opposed this court by the instant petition seeking redirection to the respondent, state respondents, to disburse an amount of rupees 2 lakh in terms of a notification dated 14 lakh or
15, my lord.
huh?
1511, my lord.
15 wrongly typed or what? 15/12/2014 of the Revenue and Disaster Management Department. Full stop. The name of the petitioner is that late Aziz Ali alias Aziz Ali died in a road traffic accident which occurred at a public place on 14/2/2023. Issue notice returning as so and so. Extra copies 3 of this.
Obliged, my lord.
4 weeks.
May I please?
Hmm.
In this case, your lordship, the son of the petitioner, your lordship, had died due to murder on
Compensation is determined or what?
lordship,
Compensation, your application has been
under the
considered or not?
not considered, lordship. That's why we are before the your lordship.
Hmm?
Not considered till date.
Then you prefer appeal.
Lordship, after the application, filing the application, department issue a notice to the petitioner and accordingly on 05
When?
21/09/2023,
21.
09/23, your lordship, at page 39, your lordship. And since then, your lordship, has been pending.
Did you appear or not?
Appear, your lordship, on 05/10/2023, your lordship. We have made a statement at page 6, your lordship.
They might have proceeded, but maybe because of concurrence. Heard Mr. Sayakanal.
Hearing for respondent number 2, state legal. I have submission to make it. We have received an instruction in this matter. I may be allowed to place the same before your lordship. It has been addressed to member secretary, state legal services authorities. The effective part of the document is at second last paragraph. It reads, your lordship, DLSA Barpeta has received the application from Shobha Khatun and Abdul Rashid for alleged murder of their son, Mukut Ali, for victim compensation in connection with Howley PS case number 67 of 2022. This case has been registered as victim compensation case number 30 of so-and-so of DLSA Barpeta, and notice has been issued to the applicant. But the applicant did not appear on 5th of October 2023 and the matter is still pending.
Lordship,
Lordship, this is
notice
You
issue-
appear?
Lordship, yes, lordship.
You appear. We will close this.
Lordship.
We will close this.
Lordship, as per their instruction, your lordship, we have not appeared, but notice was issued.
Pending inquiry, it is there.
Yes, lordship, we will appear.
Why should we keep this writ petition on board.
Lordship.
You appear
Lordship.
heard, Mr. S.I. Consultant Counsel for the petition. I got one clear. Petitioners. Mr. N. Goswami, Learned Junior Government Ratan for the respond number 1, 3, and 4. And Mr.
R. Chauhan on
R. Chauhan,
R.S.
Learned
Chaudhary.
Counsel representing
R.S. Chaudhary, Miss
R.H. Chaudhary, Learned Standing Counsel, Assam State
Legal
Legal Services Authority for the respond number. Full stop. The petitioners have claimed that they are parents of one late Mukut Ali. Full stop. The petitioners have contended that their son was killed was killed on 27/4/2022. Full stop. And in connection with the murder of their son, a crime case, Howley Police Station case number 67/2022 for the offenses under sections 143, 120B, 302, 201, Indian Penal Code was registered, and after completion of investigation on 31/8/2022, the investigating officer of the case had already submitted a charge sheet under section 173(2) CRPC, finding a prima facie case against a number of accused persons mentioned therein. Full stop. It is the further case of the petitioners that they submitted an application on 16/9/2023 before the District Legal Services Authority of Papeta for grant of compensation under the Assam Victim Compensation Scheme 2012, as amended by a notification dated 1/2/2019. Full stop. The petitioners have approached this court with a grievance that after submission of an application, then why you have annexed page 39? How can you, if you have not received, if you have not received
Yes,
the notice, how can you annex this?
Lordship, notice was received and accordingly we are FIR, but as per instruction, we are not FIR. That is the difficulty here, Lordship.
It appears,
Yes.
I will see,
Lordship.
you have received the notice.
Yes, Lordship.
You have come up with the allegation that you appeared and nothing proceeded.
Yes.
So it appears privacy, you are wrong. They had received a notice dated 21/9/2023, whereby the petitions were asked to appear before the respondent number 3 on 5/10/2023. But thereafter, the proceedings has not been brought to any logical conclusion despite their appearance on 5/10/2023. Full stop. The contention made by the learned counsel for the petitioner has been controverted as regards their appearance before the respondent number 3 has been controverted by Mr. Chauhan, Learned Counsel appearing for the respondent number 2 on the basis of written instruction, communicated by him, instruction communicated by him of by letter number so dated 16/5/2000. From perusal of the letter dated from perusal of the contents of the letter dated so dated 16/5/2024. It transpires that the application submitted by the petitioner has been registered and numbered as victim compensation case number 30/2023. And notices were issued to the
Petitioner number 2.
For her appearance before it on 5/10/2023. Post of. It is mentioned that despite receipt of the notice, the applicant, that is the petition number 2, did not appear on 5/10/2023. Post of. Due to non-appearance of the applicant, the proceedings of victim compensation case number 30/2023 is pending as on date, pending inquiry as on date, and the compensation amount could not be decided. Full stop. Notwithstanding the rival contentions as regards the appearance of the applicant or otherwise in victim compensation case number 30/2023, it is evident that the proceedings of the said case, victim compensation case number 30/2023 has not is pending inquiry as on date, and due to non-completion of the inquiry, the compensation amount could not be decided till date. Full stop. For the purpose of expeditious disposal of the case, so and so case number, it is it appears proper for the petitioners as the applicants of the said case to appear before that as point number 3, so as to facilitate an expeditious consideration of their claim made for compensation under the victim compensation, Assam Victim Compensation Scheme, 2012. It is therefore Mr. Akon, Learned Counsel for the petitioner, has submitted that the petitioners stroke applicants of so and so case number would duly appear before the respond number 3 for expeditious consideration of case number so and so. In the above obtaining fact situation, this court is of the considered view that instead of keeping this petition pending, the same can be disposed of with a direction to the petitioner to appear before the respond number 3 at a on a date appear expeditiously, immediately within a period of 2 weeks from today. And in the event of their appearance, the respond number 3 shall bring the proceedings of victim compensation case number so and so to a logical conclusion by completing the inquiry and deciding on the matter of compensation in an expeditious manner. Full stop. learned counsel for the parties have submitted that it would be Mr. Learned counsel for the petitioner has submitted that the petitioners would appear before the respondent number 3 at 10:30 a.m. on
22 Monday,
20,
22,
22,
5.
it is too early, 10 days. Yes, 27
Lordship.
on 20 at 10:30 a.m. on 27/5/2024. So Mr. Chauhan and Mr. Goswami have agreed to the said submission. So with the above observations, with the observations and directions made here in above, clarification stands disposed.
Lordship. Deep cut.
Item number 31. In this case, the petitioner is challenging an order passed by the Central Board of Direct Taxes, whereby my application for condemnation of delay in filing of the return was dismissed. In fact, the tribunal, by deciding the appeal, decided against me, with giving me liberty to approach the Central Board of Direct Taxes under section 119B, because the power is conferred on the Central Board of Direct Taxes under section 119B of the Income Tax Act, that in case of genuine difficulties, the CBT can pass the orders. Now I filed the approach the CBT, but the CBT, without examining the genuine difficulties in a mechanical way, has dismissed the application. Against the income tax appeal passed by the tribunal, I filed an appeal, but I'm coming for lawsuit against the order passed by the CBT. Now, there are various decisions of the different courts that the genuine difficulties has to be examined in a proper way by the CBT. Without that, the CBT cannot pass the orders. At this stage, I'm paying for a notice only.
Notice. And what about the statutory appeals?
Against the tribunal's order, I filed the appeal.
Pending before this court.
Before this honorable court,
Then individual petition will be proper course. The issue is also pending before a division bench.
That issue is on the merit, here not on the where the liberty was granted to approach the condemnation. That is not there,
But ultimately, issue is condemnation of delay.
No, in that case, not condemnation delay.
Okay.
In that case, it is merit, that whether deduction will be allowed or not.
Yes, Mr.
At this stage, will not notice.
Which is the impugn order? Page?
Page 156,
156. Hard Dr. A. Chara, Senior Counsel, assisted by Mr. S.J. Soikia. Huh? B. Sharma, Learned Counsel for the petitioner. And Mr. S. Setia, Standing Counsel, Income Tax Department. For the respondent.
All the respondents.
For all the respondents. In this petition, the petitioner has assailed an order dated 26/9/2023.
23.
Passed by the 23.
Passed
by the Central Board of Direct Taxes. Whereby the application submitted.
At page 168, 6 conclusion portion.
Application submitted by the petitioner on 6/2/2023. Seeking condemnation of delay under section 119(2) of the Income Tax Act. Filed by a petition under section 119(2) of the Income Tax Act. Seeking condemnation of delay in filing income tax return for allowing the benefit of claim under section 80 IC. This is Roman 1 or
My lord, it is
I?
I, my lord.
I. IC of the income tax section or the assessment year 2018 and 2019 has been rejected. Post of Mr. Dr. Saraf from the Council for the Petition has submitted. Senior Council for the Petition has submitted that the respondent board has not considered the aspect of genuine hardship or what is the word?
Genuine difficulty. Genuine hardship.
Quote unquote, genuine hardship in the proper perspective. Issue notice returnable on so and so date as Mr. Chetia has appeared, accepted issuance of formal notice
Yeah, the 1819 likhi sir.
is dispensed with extra copies, 3 working days. Genuine hardship or genuine difficulty?
Genuine hardship.
Quote unquote, genuine hardship.
Order dated 26/9/23.
Right. 26/9/2023.
Yes.
Okay. Bracket or deduct annexer. Annexer
Page 160.
14. Annexer 14.
Well, an actual and the assessment year will 15-16.
Huh?
Assessment
It
year.
is wrongly typed or what?
It appears to be wrongly typed.
Huh?
I will correct.
Wrongly typed. Okay.
Originally, it's my lord at page 167.
2015-2016.
My lord. I'm
Okay.
sorry, my lord.
Okay.
Correction to the motion. But the may please your lordship, my lord.
Yes.
Very short issues that bringing by this petition before lordship, my lord. I'm a head assistant in the.
You want great pay?
Yes, great pay. I am paying 9,100. It should be 10,300.
Okay, we'll issue notice.
My lord, it can be disposed of by taking instruction also. If lordship issues notice, then because I'm retiring on next month, 30th of the next month.
Next month?
Last day of the next month, I am retiring.
Okay, anyway, we have to decide. Anyway, we'll fix a date. Today is what?
Today is 17.
17. Okay, 17 and say, who are the respondents?
Plus state,
All state.
state and the state and high court. My lord.
Okay. We can make it returnable on 10th of June.
My lord, can it be little earlier? My lord? If not inconvenient, my lord. Because 2 weeks is still remaining, my lord. 2 weeks still there for the month.
No, there are difficulties also on the part of the court.
I understand, because it's matter assigned to your lordship.
And I may not be available in single bench. That is also the.
My lord.
These are difficulties
I understand.
to face. If your case is admitted, we can dispose of on the next date.
My lord.
Otherwise, if the issue arises, no, we have to.
No,
issue
because
notice, then
I have adduced evidences, my lord,
Okay.
that all the,
You wait at least. Not that it cannot be rectified later on.
yes, yes.
Third Mr. Shomwal and a council for the petition.
Paper 1.
And Goswami. 1. Mr. Z. Bosho. 2 is there. I am Boro. Representing Mr. B. U. and Standing Council Finance Department for respondent number 2. Mr. Z. Bosho. Standing Council, Guwahati High Court for the respondent number 3, 4, and 5.
5.
Bosho. According to petitioner, the petitioner who is serving presently as
Head assistant.
head assistant in the establishment of the respondent number 5, is entitled to a great pay of rupees
10,300.
300 on and from 21/01/2020. Post of. As the petitioner is retiring on
30 June.
2024, on superannuation, comma, hence the repetition. Issue notice returnable on what's, if I said?
10th of June.
10th of June. Appeared accepted. The learned counsel for the respondents shall make endeavor to obtain necessary instructions for
Final disposal.
necessary instructions for an expeditious consideration of the issue raised involving the state.
Extra copy.
And extra will be Monday, madam. By Monday. Extra will be by Monday. madam.
Monday.
Item 34.
Met with lordship. Matter
Yes.
is for demarcation of land, my lord. The petitioner was submitted one representation before the concern.
Deputy Commissioner Lodge, he has to submit before Circle Officer Lodge.
Huh?
He has to submit application before Circle Officer Lodge.
That too in a format,
Format.
standard format, as per the office memorandum.
Huh.
He has annexed some
Wrong.
other wrong office
Page
memorandum.
42. That is regarding income certificate Lodge.
What do you have next, Mr. Islam?
My lord, annexure,
Alexa, page 42, come to page 42.
page 42, my lord, that is the office memorandum, my lord.
You want demarcation, and you have annexed a notification of income certificate.
Sorry, my lord, income, that is the office
Huh?
memorandum, in this office memorandum, income certificate, all the income comes from this.
Where is that? Demarcation.
No. That is different Lodge. That is
Date is
Income
same,
certificate.
My lord, last one, it is.
date is same, but there is a different office memorandum.
But I have in office memorandum regarding income certificate.
Yes,
Sorry, my lord, sorry, my lord. That the office memorandum also that is same.
Bring it so that we can say that you submit accordingly and they should dispose of.
Yes.
It's not correct.
My lord, kindly, representation.
Careless
An extra
approach.
6 may dispose of, my lord.
No, that cannot be, right?
But.
has
There
to
is
be
a proper
something that-
procedure.
Memorandum is not, it is.
Circle officer does not.
That I'm doing.
You have
My lord, kindly.
made your claim on the basis of this. This is regarding income certificate.
Sorry. There is.
And in the other notification also, there might be some requirement.
My lord, on the.
Down here,
My lord,
in the last but what column, page 44. File properly repetition.
my lord, in the next week, my lord. That may,
This is not to be entertained.
then I may be done.
You better
My-
file a proper application,
but-
repetition, then we can
My lord,
dispose of. I don't think this is proper. There is a separate notification.
yes.
Whether
but
44
date
is
same, my
correct.
lord.
Yes, 44 is correct.
Date is same.
44 is correct, yes.
44 is correct.
44 is correct.
Then whether he has submitted these documents.
That the document is submitted before the
Huh?
circle officer. has-
No, he has written a representative before Deputy Commissioner Lodge.
Page 27.
But circle officer is the main authority.
Yes.
Lodge.
Deputy commissioner is the appellate authority.
Yes, yes.
Ah,
Only
They
pay for
do not
direction.
comply themselves with the procedure
Right.
and come up with a repetition.
Right.
Yes, Mr. Islam, what to do with this repetition?
But only pays for direction to.
As the
demarcate land,
petitioner
but,
has not
only
approved the proper authority, I can say that.
I will do.
Huh?
Proper. authority. I will.
Heard Mr. B. Islam. Learned counsel for the petitioner. And petitioners. A voters IG,
1.
revenue, 1,
About 2 and 3.
and Gusami. Respond number 2 and 3. Word is 4 and 5.
4 and 5 are the private respondent who
Huh?
occupy the government land, my lord. Government land means, my lord, the highway NS 37, my lord.
What is your case?
Acquisition the 2 bigha, 115 less.
Absolute.
And that land was
land,
in that.
revenue, village. Ramsaran, so who died in so and so. Died on so and so. Mr. Islam, please read paragraph 4.
My lord, I that the petitioner basically said that a plot of land measuring 2 bigger to 4 katha, 10 lessers under Dag number so and so partner Dag number 102, KP partner 109 and 2 bigger 2 katha, 19 lessers of land Dag number 103, KP partner number 10110 in the district of Kampur Metro Assam, which belongs to
The story appears to be very different.
The matter is this, my lord, in the year 2000, my lord, kindly see page.
Okay, your relief is only with demarcation of the land.
My lord, my lord.
And before whom you have submitted?
The representation before the circle officer.
Submitted before Deputy District Commissioner.
My lord, my lord.
And according to you, circle officer. So you file proper application.
My lord, I'll
Mr. So-and-so, the petitioners have claimed that their owners of parcels of land measuring 2 bighas, 4 kathas, 10 lessas, covered by Dag number 102, and 2 bighas, 2 kathas, 19 lessas, covered by Dag number 103, comma, in Revenue Village, Bhogpur, Gaon Kisamot, comma, Sunapur Revenue Circle, District Kamrup Metro. Full stop. It is a further case of the petitioner that they submitted a representation before the District Commissioner Kamrup Metro on 21/3/2024, seeking demarcation of the boundaries of the aforementioned parcels of land. Full stop. As the said representation has not been paid hitherto, comma, hitherto, HEED. Hitherto, the petitioners have approached this court by the present writ petition. Full stop. Both Mr. Photosaichi and Mr. Goswami have submitted, comma, in unison, comma, that the district commissioner stroke district collector is not the authority, proper authority to demarcate, to extend the service of demarcation.
Yes.
It is the jurisdictional circle officer, that is whom Punapur, the circle officer, Punapur Revenue Circle, before whom an application for demarcation is to be made, since the petitioners have not submitted before the application for demarcation before the appropriate authority, comma, the prayer made in this petition in the form of a direction to the District Commissioner Kamrup Metro to dispose of the representation does not appear proper. At this stage, comma, Mr. Islam Learned Counsel for the petitioners has submitted that the petitioners will approach the jurisdictional circle officer with an application for demarcation
In standard application
in standard application format along with all the supporting documents. In view of the above fact situation, in this petition, he is closed, reserving the liberty to the petitioners to approach the jurisdictional circle officer by way of an standard application form along with all the supporting documents seeking demarcation of the process of land, stated to have belonged to them, stated to have owned and possessed by them.
No passage at all, legally or property, my lord. When the petitioner got the property by legally or my lord. Legally or property.
I've already recorded,
But-
you have claimed you are the owner and your
Owner.
occupation.
Deep look.
May I please, Your Lordship. Lordship, but the petitioner is the owner of two vehicles, Lordship.
Hiring charges.
Lordship, not only hiring service, Lordship, one of my vehicle that was used, my vehicles were used since 2014. Since establishment of the judicial court at Amingaon, Lordship. They requested me to provide a vehicle, Lordship, the district administration. I provided them a vehicle, Lordship. They again requested that the vehicle was bigger, so need a smaller one. So I again bought a new vehicle, modified it for the purpose, and provided it to them. So in 2014 itself, Lordship, and subsequently they requested for two vehicles.
What are the prayers, please come
Lordship,
to,
prayers is, Lordship, one of my vehicle.
no, what are
now
the
has
prayers?
been
Let us see,
outside
examine your
without having any
prayers.
Lordship,
To was cancel direction issued by in charge the district commissioner, 22/2/2024. What is
Lordship,
that
that-
letter? What is that?
that letter is at Lordship, page, Lordship, 28, Lordship, and it's a 5.
Reference to surgery and requested to place your vehicle at premises of so and so. On so for purpose, you are requested to provide fuel.
This is
along
another
with the
person, Lordship.
vehicle. As per with the vehicle, as per requirement. That is obvious till the end of 3 years from the date of deposit going so. Now, you were agreed by what?
Lordship, so you see below, Lordship, serial number 7, Lordship, I was provided a copy, Lordship.
Huh?
Service Tapan Kumar Das, owner of vehicle number so and so for information and necessary action.
No, page 28 I am reading.
Lordship, exactly, Lordship.
Huh?
This above person, above Lordship, the first para, Lordship, refers to that some other person has been brought in. He was to provide the vehicle and without giving me any notice or
So,
informing me.
proprietor, who is this?
This is another respondent number, Lordship, 7.
Huh?
Without informing me, Lordship, they ousted my vehicle, Lordship. Lordship, below, Lordship, see below, serial number 7, Lordship, copy to and
Your vehicle has been released.
Lordship, without any
Yes.
reason, Lordship, without any reason, without explaining me, and that too, Lordship, they provided me this letter. This letter was issued on 22/2/24, as Lordship can see, the letter date. Lordship, they provided it to me, Lordship, in a subsequent date, Lordship. After 2 months, Lordship. It came to me, Lordship, on 1/4/2024, Lordship. I went for that.
Direction that please direct the respondents to resume using the vehicle.
Lordship, this is a backdated order, Lordship. In fact, I was not provided the fuel. I paid for the fuel. I provided for the hire
No, here
charges.
it is not hiring charges, non-payment of hiring charges,
Not exactly for hiring charges, Lordship.
but release of vehicle. It is a contractual thing.
Lordship, how can they do it?
See,
At least they should have
damages.
I have given him service for 10 years, Lordship.
Right, you can seek at best damages for that, just because your vehicle has been released.
And Lordship,
An issue notice at this stage, we cannot pass an interim order that please keep his vehicle
I understand, Lordship.
in use.
I
That is
understand, Lordship.
difficult to pass an interim.
I understand, Lordship.
We can issue a notice
Lordship.
because your prayers are very strange.
Lordship. Lordship,
Direction to provide petrol, direction to take back my vehicle.
Lordship, 2 of my vehicles are there.
Right.
See the modus, Lordship, how they are walking, Lordship. 2 of my vehicles are there.
One, they want to stop, Lordship. They want to.
We know how they operate. They don't pay the hiring charges in time.
Check.
I know, but so far as the issuance of REIT is concerned,
Lordship. That I understand,
it's
Lordship.
difficult.
Lordship, I understand, Lordship.
Keep his vehicle, Mr.
Lordship, that I understand,
If I
that I
go on
understand.
passing order that
But this order was issued behind my back, Lordship. I was there approaching them for
Mr.
funds, Lordship.
M. Bhagavati, Learned Counsel for the petitioner. Mr. S. Borua, Learned Junior Government Advocate. For all the respondents?
No, there are two private respondents.
private
One, two,
respondents.
three.
1 to 5.
5.
1 to 5. Full stop. Which vehicle was this ASFC?
A01 FC, Lordship. 0579.
It was in under which the respondent
Lordship.
for how many years?
These exactly I cannot say, Lordship. Two of my vehicles are there for since 2014, Lordship.
Okay.
In fact, Lordship, if we go to the initial engagement letter of 2014, we filed the bus bearing number AS12B 9787.
Lordship.
So this is another one, whereas in that copy marked to the petitioner, it has been referred to another vehicle, the AS01FC 0579.
That I have explained in my.
It is the case of the petitioner that he is the registered owner of a vehicle bearing registration number AS01/FC-0579. Full stop. The subject vehicle, within bracket, the subject vehicle was being used by the respondent authorities for the transportation of under trial prisoners since a number of years.
That's it.
Full stop. But by the impugned order dated 22/02/2022, which was not addressed to the petitioner directly addressed to the petitioner, the respondent authorities had arbitrarily released the subject vehicle, and the petitioner was requested to take over the vehicle from the office of the respondent number.
Lordship, Deputy Commissioner, District. Lordship, 3.
3.
That's it.
Full stop. And the case of the petitioner is that after engaging the subject vehicle for a number of years, the respondent authorities by the impugned order dated 22/02/2024 has arbitrarily taken the decision to release the subject vehicle from service. The same has put the petitioner into has prejudiced the petitioner. Issue notice.
So at the same time, the petitioner may be asked to produce the initial engagement letter as regard these vehicles which has been marked in this notice. Because ultimately the petitioner's claim is with regard to two vehicles which has been used from 2014.
Prayer.
2014.
Prayer, I have seen the prayer.
But when we go to Annexure 1 and along with that we the reading of Annexure
paragraph 9, first prayer. Impugned order dated 22/02/2024. Second prayer, to resume using the vehicle, only this vehicle. And third prayer, we'll see about that.
Lordship.
To provide fuel to the vehicle.
Lordship, my other vehicle has been provided.
We'll do that. Issue notice returnable for
Lordship.
as so appear accepted. Nazir proprietor over there.
Lordship, Nazir does all this official process, Lordship. Lordship, he is the main person behind all this, Lordship.
He is
Lordship, Lordship may well know Lordship. He is the most powerful person, Lordship, dealing with this kind of matters, Lordship.
What you have alleged? Let us see.
Yes.
Melaf ID.
Lordship.
Let us see Melaf ID. What is your statements? What you have attributed to him?
Para 6 Lordship, it is enrouted through the office of Nazir Lordship.
Huh?
Para 6 Lordship, last point Lordship.
Lordship may go to paragraph 16 also.
Where you have alleged Melaf ID?
Lordship, last line Lordship.
Which paragraph?
Lordship, para 6, page 10. I have not made a specific allegation as such, Lordship.
For against a person, you are naming a person.
Made a specific allegation.
Lordship may kindly go into paragraph 16. This is some serious allegations has been brought in. So with regard to Annexure 6, it is to be noted that it is Nazir who is entrusted the duties of running the vehicle, the task of providing fuel and maintenance of all such records. He is all powerful in these affairs. And the present Nazir Sri Niranjan Boro, response 6, was proud enough to declare that he had the power to throw away both the vehicles and the petitioners and ruin his business.
So let him respond then.
Yes.
Let him respond. Will issue notice.
Yes.
Petitioner shall take state for service of notice. Among the respond number 6 and the respond number 7 by registered for PPA. Mr. Bhagavati, Mr. Bhagavati, the Learned Counsel for the petitioner has drawn attention to the statements made in paragraph 6 and paragraph 16 of the petition to explain the reason for implementing the respond number 6.
Much obliged.
My pleasure, Lordship. My lord, it's against my lord, order passed by the my lord, revenue authority. That is, your lordship will find it page 37, man. In fact, my lord.
Why you are sitting for 3 years?
My lord, in fact.
First question.
Yes, my lord. So, my lord, there are some, my lord, financial difficulties, my lord, on the path of the petitioner. He is a woman, my lord. And
the second question. Is there not an appellate authority?
That is there, man.
Both.
Yes, ma'am. That is there, man.
Yes. Both. And that authority also has the power to condone delay.
Yes, ma'am.
And also trace out one full bench judgment.
And one moment. How he is aggrieved? The order is in his favor.
Whatever,
No,
in
no.
his favor.
In his favor.
No, that was in my favor. Finding is in my favor, but order is in my lord, to the country, my lord.
I think on both the accounts, I think this is an appellate order. Appellate order.
Yes, yes, 147.
Means appeal.
Yes.
So clear statutory provision
Yes.
in Assam Board of Revenue
Yes.
and Assam Land and Revenue Regulation.
Yes.
And that, let us see. Thereafter you can.
Yes, yes. In fact, my lord,
Otherwise,
226.
these kind of petitions are filed only after Board of Revenue order.
Yes, yes. But at the same time, my lord,
Only.
26 doesn't exclude my lord, to entertain my lord. That
But
is-
also it is laid down whether any principles of natural justice has been violated. Totally not.
No.
You appeared.
I
You appeared in the proceeding,
Yes, yes,
right? What fundamental rights?
yes,
Only on 4 exceptions.
yes.
One, principle of violation of the principles of natural justice, total violation,
Yes.
no notice, behind your back. One. Second is that violation of the fundamental right.
Yes.
Third, ultra-virus.
Lordship.
If you go by the whirlpool
Yes.
and laws are settled,
Yes.
if efficacious statutory remedy is available, only under these exceptional circumstances, a petition is to be entered in.
Lordship.
Writ petition is maintainable,
Lordship.
but whether it is to be entered in, if you have noticed orders passed today by this court, I have said not to be entered in.
That is,
I have not said not maintainable.
in fact, my lord, finding is in my favor, but my lord, order is, my lord, to the contrary of his own decision, my lord.
Hey, come. Oh, 147.
Yes, conference.
147. Mr. Bora, you find out a full bench judgment.
Lordship.
Of the court, this court. One 147 or what?
147.
147A, but
A.
A. By Deputy Commission. And what is the power of condemnation is available or not?
that period is, my lord, as per 148, that is 60 days, my lord. 60 days.
Assam Board of Revenue. Within what time?
60 days, my lord, as per 148, section 148.
2 months. 148, 1A.
Subsection 3 is there.
Yes.
There is nothing
Yes.
like extended period of limitation. It is full. But before an April,
The lordship may give
Pardon.
liberty,
Mr.
my
J.C.
lord, to
Bora.
approach, my lord. Your lordship may give, my lord, liberty to approach, my lord.
heard Mr. J.C. Bora, Learned Counsel for the petitioner. A. Borasaji, Learned Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. Mr. S. Borua, Learned Junior Government Advocate Assam for the respondent number 2 and 3. Post the petitioner has instituted the instant writ petition to assail an order dated 04/02/2021 passed by the Additional Deputy Commissioner Nagaon in case number page 37, Miss Appeal number 75/2018-2019. The order dated 4/1/2021 has been passed by the Additional Deputy Commissioner acting as an appellate authority against an order dated mutation order dated 15/11/1990.
Yes.
Or what?
And 15,
Yes.
1990 and my lord, 1/10/2008, my lord. Yes, sir. 15/11/1990, my lord.
Against an order of mutation passed by the against an order of mutation. Full stop. Para. Section 147 of the Assam Land and Revenue Regulation 1886 has provided for an appeal to the Assam Board of Revenue Assam from an order from an original or appellate passed by a deputy commissioner. Full stop. As per section 3 within bracket M, comma, deputy commissioner, quote unquote, includes and shall be deemed always to have included the additional deputy commissioner. Thus, the order dated 4/2/2021 is an appealable order. Full stop. Though a period of limitation of two months is provided in clause A of subsection 1 of section 148 of the Assam Land and Revenue Regulation, subsection 3 of section 148 as provided that an appeal can be admitted after the period of limitation prescribed therefore by section 148 when the appellant satisfies the Board of Revenue to whom Board of Revenue that he had C had sufficient cause for not presenting the appeal within the prescribed period of limitation. Full stop. Moreover, the appeal in the moreover, the petitioner has order must have been executed by now.
Not my lord, not yet executed, my lord.
Okay, prepare for stay also.
Yes, ma'am.
Okay, in view of the above, in view of the availability of the provisions for appeal, provisions for preferring a statutory appeal, which appears to be an efficacious and adequate remedy, the writ petition, at this stage is not entertained at this stage.
Yes.
Is not entertained, reserving liberty to the petitioner to avail the statutory appellate remedy first, for exhausting the statutory, exhausting the remedy of statutory appeal before the Board of Revenue, post of Assam. I think that will,
Yes, that will.
and find out the full bench judgment where in exercise of $151, 3 years, even 8 years, 10 years. Board
Obliged.
can condone.
Finding method, item number 15.
Yes, sir.
Yes, Lordship, I've gone through the judgment. Yes.
Yes. What is there? I am not ready. I remember only. I have forgotten.
Your Lordship, this judgment was passed against the order of the Honorable.
No, what is the remedy? Tell me.
Your Lordship, in this,
Suppose in the context of your case.
yes, in this case, Your Lordship, the Honorable Allahabad High Court observed that the protest.
What the Supreme Court has observed?
Yes, they have this.
Huh?
Set aside the order of the.
No.
I have not gone thoroughly, but.
Suppose your FIR
Yes, Your Lordship.
resulted into a final report.
Yes, Your Lordship.
Right?
Yes.
Then you can file a protest petition.
Yes.
Right?
Yes.
Then what are the options available to the magistrate? What is there?
He may accept the protest petition and give it for further investigation, or make it a complaint petition, or he may accept the FIR. Final report.
And in the acceptance of the FIR, whether that will exhaust the remedy. What are the options to the complainant?
I may go for filing a complaint under 200.
all those are there.
Yes, Your Lordship.
So
But
why you are
in my
instituting?
case, the petition was accepted and further investigation was given.
Right, then thereafter, he can monitor
Yes, Your Lordship.
under 156(3),
Yes,
right?
yes, Your Lordship.
And if he can change the investigating officer
Yes,
under 156(3),
yes,
Sakari Bosu has said,
yes.
Vishnu Thakur has clearly explained, then why this repetition?
I am allowed to withdraw this.
Simple.
Yes, Your Lordship.
Mr.
M.R. Sodial.
M.R.
Sodial.
Sodial. Okay, I'll observe that. What is the citation? Just hand over, I'll again hand it over to you. Heard, Mr. M.R. Sodial, learned counsel for the petitioner, and M.S.S. Borua, learned Junior Government Advocate Assam for the respondent number 1 to 4. It will report it as a report it. Mr. Sodial, learned counsel for the petition has submitted that in view of submission of has submitted that as the investigation of the case, Dhubri Police Station case number
Diffuse.
Diffu 114
Yes,
stroke
22.
2022, instituted on the basis of a first information report lodged by him, resulted into a final report, final report number 12 stroke 2023, he would avail appropriate remedy under the provisions of the available to him under the provisions of the Code of Criminal Procedure 1973, including section 156 within bracket 3 and in the light of the principles laid down in
Vishnu Kumar.
Sakari Basu so-and-so, reported in so-and-so, and Vishnu Kumar Thakur Tiwari, reported in so-and-so. So he has thus submitted that he may be allowed to withdraw a petition, to avail the remedy permissible under the law. In view of the above submission made by Mr. Sodial, learned counsel for the petitioner, the petition is closed, reserving the liberty
Deeply
to
obliged.
the petition as sought for.
Deeply obliged.
Citation is a file.
Stay beginning item number 51.
My lord, here we have filed this IA for stay of the interim.
Hey,
Yes.
no, petition file to the problem. It is the order, which order in the
Order,
petition?
at page 99, relevant portion, page
Okay.
101.
Okay, is it passed by this court.
Yes, my lord.
Or it is in prosecuted. Let me read the order first, which
Yes.
request to vacate it. It is in prosecuted on behalf of the petitioner. By relying upon a copy of the journal that updated it of cutting persons of that covered by to transfer in the names of sons and daughters of Fatemali including the petition. Pursuant to an order dated so and so the jurisdiction of covered by petition is agreed by the letter to so and so. 16/12, whereby circular officer was looking to provide certain period and eviction drive at Tinsukia, Sotian Library Market. In a circular petition, of the copy of the Jamaman you referred above. It has come to the knowledge of the petition to further and commentary has been converted to government and by changing the compiled with it to government as number so and so pursuant to an order dated so and so. Okay. Now IA is for vacating that order.
The interim order, my lord. The applicant is one of the villagers, my lord. And the eviction drive was, my lord, carried out on the
Villager,
the villagers, they have made a
petitioner is claiming that that plot of land
is
originally belonged to him.
Yes, my
Patta
lord.
land.
Yes,
And
my lord.
behind his back, it has been made Sorkari.
Yes.
That is, and in the name of some
market.
Now, who are you?
My lord, I am the one of the village public, my lord. On the basis of a public petition, a complaint, my lord, the eviction drive was carried out. Your lordship may kindly see the public complaint at page 91, my lord, translated version. 93 is the Assamese vernacular.
It's a I wrote a serial number.
Running page, my lord.
Running page. Description pa. Itu description dekhle to. Itu running page jape 76 pa up करते. 76 pa up करते ठीक है. Huh? Yes, running page. IA is starting from 76.
Yes, my lord.
I'm wondering why. It should not have been.
Yes, my lord.
So I have asked the court master to seek a clarification from the registrar. Yes, 90.
Page 93 is the Assamese version. my lord.
91.
May I read the English
Assamese.
English version of the
There is
document? সন্মানপূৰ্বক ৰাইজৰ বিনীত নিবেদন এই যে তিনচুকীয়া চতিয়ান বজাৰত নামত থকা চৰকাৰী মাটি কিছুমান স্বাৰ্থলোভী মানুহে নিজৰ পৈতৃক সম্পত্তিৰ দৰে বিল্ডিং ঘৰ নিৰ্মাণ কৰি সম্পূৰ্ণভাৱে বেদখল কৰি ৰাখিছে।
Okay, this is public complaint.
Public. And the petition applicant is one of the public, my lord.
Right,
So,
public.
on the basis of this complaint, my lord, circle officer made my lord.
General, কৃষক ৰাইজৰ কেঁচা সামগ্ৰী বিক্ৰী কৰিবলৈ মুকলি বজাৰ কৰিবলৈ চৰকাৰী মাটি নাই। It is not the case that they are কৃষক.
Yes. Yes, my lord.
Now, it is not the case that these applicants are
Applicants are they are the,
cultivators.
yes, my lord.
Right,
They
this
sell their products in the market, my
Huh?
lord. In the bi-weekly market, my lord.
Where have you stated?
I have stated, my lord, in my application.
Now, is there any market committee or not?
My lord, this is really is under the panchayat, my lord.
Huh?
So,
Panchayat?
yes, my lord. So on the basis
Huh?
of this
They are
complaint,
not, and you will be claiming your trading rights in the market under the panchayat.
yes, my lord.
You cannot go there if it is allotted to panchayat, suppose.
This is
This
yes,
land.
my lord.
If it is panchayat, you are saying, if it is allotted to panchayat, there will be definitely, panchayat will be the jurisdiction.
Under the
Will be
Gaon
having the
Panchayat,
jurisdiction.
Gaon Panchayat, yes, my
Now,
lord.
you will be claiming your trading right
My,
only through the panchayat authority.
yes, my lord. My lord, they were, my lord, selling their products in the market, but my lord, the writ petitioners, my lord, they have, my lord, encroached the land. So their complaint was made. Accordingly, a spot verification was done,
That
my
I
lord.
have seen, that I
And
have
circle
seen.
officers report, your lordship may kindly see annexure C page 94, my lord. Enquiry was made and a circle officer's report is there, my lord.
Now, I am trying to find out whether you fall in the category of a person aggrieved.
Aggrieved means, my lord, they are the villagers and they sell their products in the market, my lord, because
He is saying my land, my land.
it is not his land. That is why
No,
the
he has
report is here,
projected.
my lord.
He has projected.
He has projected. But the report of the circle officer is
Let us
here,
see.
my lord.
Let us
At,
see.
Page 94, my lord. Is the English one, my lord, version. The application submitted, the applicant submitted the application for eviction in respect of the
95 is the original report.
94, my lord, the running page, my lord.
95 is the original report.
Yes, my lord.
Circle officer submits this kind of report.
Yes, my lord. And 94 is the, my lord,
Mr.
translated version, my lord.
Over government council.
Office note is also there above, my lord, on the left side, my lord. Then another,
This
my
is
lord.
this is the kind of report the circle officer gives.
Then
Page
your
95,
lordship
90,
and
please come to page 90.
yes, my lord. Page 98, then your lordship may kindly peruse. This is the clear one, my lord. Page 98, that is annexure D.
This may be a called a
Yes, my lord.
report.
This is the information that the applicant sought information and they were furnished this information. You are hereby informed the information sought, my lord. Number 2, my lord, this is relevant. The land measuring 1 biga 3 kata 8 lectures, 1 biga 1 kata 4 lecture dark 588 under periodic patta 193 of Tinsukia Kisamat had been converted to government land for the aforesaid market and renumbered as dark number 627 by order dated 14/2/2023. In case number so and so passed by the ADC. As per the said order, out of total area of land measuring 4 kata, 8 lectures of dag number 13 of periodic patta, number 5 of Poop Chation Kisamot, 2 kata, 8 lectures was converted to government land for market and the new dag is 1510. The copy of Chita is enclosed hereby. So, my lord, it was converted long back in 2004, my lord.
Now that is his case. That it
My
was
lord,
without his
is,
knowledge.
my lord, stand is that it was done behind his
This
back.
is
He
exactly
had no
what he
knowledge.
is saying.
Yes, my lord.
This is exactly what he is saying.
Yes, my lord.
He is not saying contrary to this.
But yes.
He is also saying that in the year 2003, that dag number 588 has been converted into a government land. Dag number 627. Is it not?
Yes, my lord.
What more he is saying there is that everything was done behind my back. And otherwise, tag number 588 belong to me. Is it not?
Yes, my lord. But that
These
is
two
not
additional
fine.
facts, he said, this conversion to government dag number was made behind my back. One. Second, that the dag number 588 originally belonged to me and my family.
Yes, my lord.
Is it not? Are those facts are incorrect?
My lord, I have
One
read
thing
the
is disputed,
Jamabandi, my lord. I have
belong to their family. That is not disputed. What is disputed is that whether it was done behind his back or with his notice.
Yes, my lord. But that is done in
Well, that way.
2004, my lord. In 2004.
Nobody is coming up.
And your lordship may kindly
Nobody is coming up. Neither the panchayat, nor the revenue, nor the district commission.
And in that
And you
case,
do not fall in the category of,
then in the IA may be listed along with the writ petition, and the writ it may be hard, my lord.
that can be done. But nobody is coming up.
Pero shall I file an objection, your lordship, to this IA?
I was thinking of closing this,
Yes, your lordship.
okay, now you are
No,
seeking.
no, your lordship, if you please, your lordship.
You should have told it earlier. I was deciding the
The matter may be fixed for, my lord, hearing, my lord. A
Since
date
I
may be
has
fixed.
come. Okay, then
In the IA earlier notice was issued, my lord.
Mr. MS. Okay, I record that.
SB two.
Third MS,
SB
LD
two.
Chaudhary, Learning Council for the applicant, NMS,
S. Nazmin.
and Learning Council for the opposite party, the street petition opposed. Also heard you Sharma for respond number 6 and 7. You Sharma, who are the others? PR Monto, Learned Standing Council, Revenue Department for the OP number 2. S. Borua, so and so. For the OP number 3 and 4. And Mr. U. Sharma, Learned Council for the OP number 6 and 7. MS Nazneen, Learned Council for the opposite party number 1, that's the petitioner has paid for and is granted 2 weeks time to file an objection to the instant interlocutory application for vacations modification of the interim order dated
Dated to 21/12/23.
Place the case after 2 weeks. The
Okay.
interim order passed earlier shall continue till that.
Declare.
For admission of item number 26.
Good for it. Yes, any development?
Yes, Madam.
I think Mr. Das was.
I have given the proposal on that day itself.
We have received the proposal and accordingly they have taken steps, they have taken up with the finance department. I have the instruction.
At least one step.
Lordship.
At least one step advanced. After 4 weeks, then will be given time.
This is the proposal. They have forwarded it to.
Okay,
the
heard
finance
Mr.
department.
A.I. Uddin, Learned Council for the petitioner, Mr. Dina, Learned Senior Government Advocate Assam for the husband number 2. Any finance? Finance or standing, MS? A. Sharma, Learned Council for the respond number 3. And Mr. Iskeras, Learned Standing Council GH for the respond number 4 to 7. Full stop. Mr. Das, Mr. Nath, Learned Senior Government Advocate Assam.
16/5/24 late.
Has placed a communication number so and so dated 16/5/2024 of the Judicial Department, and Mr. Das, standing on GST, has placed a letter dated so and so. Letter number so and so dated 13/5/2024 of the civil judge, Junior Division, North Salmana, Ovayapu. From the contents of the said to communications, it transpires that the matter of creation of supernumerary posts has been forwarded to the finance department for concurrence. As per the letter dated 16/5/2024, a period of 6 weeks would be required to arrive at a final decision. Also, in view of the such situation, let the case be placed or listed on 6 weeks
28-6. Item 37 with 52.
May I please, your lordship? Lordship, we were asked to file our affidavit as per order dated 21/2 of 2024.
21.
2 of 2024. But
21,
Lordship, we're yet to
2,
file it.
21. Yes. Yes. It is a claim periodic patta holder. Yes, dispute is whether periodic patta or reserve forest.
Yes, sir.
Now, forest department is saying it has been deforested with specific boundaries. Reserved.
Yes.
Yes. Now,
Lordship, we need another 2 weeks' time. If
2
you may
weeks.
kindly grant us.
That's a fixed date, Lordship.
huh?
Fixed date, Lordship.
No. Silent. Mr.
PJ Dutta.
All the parties are same in both the petitions.
Yes, Lordship.
Huh?
Same, Lordship.
Same.
Same, Lordship.
Issue is same.
Issue is same, Lordship.
Sure.
Sure, Lordship.
Have you checked
Yes,
the
Lordship.
parties? What are the parties?
In item number 52, Lordship.
Check. Otherwise, we should not jumble up both the issues if that issue is not similar.
Earlier, Lordship, it was connected, Lordship.
Connected?
Yes, Lordship.
Yes, Mr. Taludar, parties are same.
Same, my lord. Earlier it was.
Exactly
connected.
same.
Yes, lord. Earlier it was connected, my lord.
Okay. Otherwise, it creates difficulty for a court. Okay. Hired Mr.
PJ Dutta.
PJ Dotto, learned counsel for the petitioner. Petitioners. Taludar, you appear for ministry also?
1, 3 and 10, my lord.
Standing counsel NHDCL for the respondent number 1,
3 and 10, my lord.
3,
And 10.
10. Who is for NHI?
I am for 2 and 7.
Mr. A. Bodo.
R Bodo.
R. Bodo. Learned counsel. Standing counsel.
On behalf of C Bodo.
Representing Mr. C. Borua. Standing counsel NHAI for the respondent number 2, 7. Anybody? Real areas, Mr. Talukar?
4 and 8.
Mr. PJ Talukar, senior counsel, accepted by Mr. P. Mehdi, learned panel lawyer for the respondent number 4 and 8. 9, who?
Lordship, and for 5, 6,
And MS?
V. Shohei, Lordship, on behalf
P.
V. Shohei,
Sohe,
Lordship. On
learned
behalf of
counsel
Jay Chutia. On
Jay Sutia, representing Mr. Jay Sutia. Learned standing counsel AAAC for the respondent number
5,
5,
6,
6,
5, 6, 9,
9,
11, 12,
11.
and 13.
12,
And 13.
and 13.
Yes, Lordship.
Okay. All are complete? Okay. MS so Learned Counsel representing KAAC has submitted that the instructions in deference to the order dated 21/12/2024.
21, 2, Lordship.
21, 2, Lordship.
Complete instructions are not yet received and has thus prayed for listing of the cases after
2 weeks, Lordship.
2 weeks. 2 weeks. To complete the instructions and to file additional affidavit if so advised. First of all, the prayer made on behalf of the respondent KAAC authorities is accepted. List the cases. Review after 2-3 weeks.
Obliged.
Obliged, Lordship.
14-6. That was 38-53.
May I please, your lordship?
May I please, your Lordship? Lordship may adjourn this matter for today.
My lord, that query your lordship has made, my lord. That whether ordinary artist royalty to be paid or not, that amendment has come up. We are concerned with amendment of Rule 27.
Rule 27.
Rule 27, and it is included, the third schedule has been included. Artwork, ordinary clay, 9%, and it is important that the rates is appended in the third schedule be processed and prescribed above shall be applicable in.
No, which, the green one you are reading or
Yes,
which?
ma'am.
Huh?
Yes, ma'am.
The rates as appended in the third schedule and process as specified shall be applicable. All right.
My lord.
That is the
That
question
is the
I
question.
asked.
Yes, ma'am. And
Mr. RM Das is not available or what?
No, Lordship is out of
Delhi
station.
not coming.
Lordship is out of station.
not only
Due
that
to
query
urgent
was,
matter.
That is a query. So your contract completed
yes, ma'am.
earlier to
Already
amendment.
this notification.
Earlier to amendment.
Yes, ma'am.
And rate is
Now it is 9%.
9%. So according to you, even if this is made applicable, it is not
It will not hamper
to be applied in
my
your
case.
case.
Yes, that is.
Lordship.
That is
may
a
fix-
query you have made.
Yes,
I think that is a pertinent query.
my lord.
Lordship may fix any other day next week.
Oh, Mr. Fadurika, I will not be sitting in single bench.
No, my lord, since the matter has hard at length, it may be kept as part
Put
heard.
it to the other court, then I'll.
It may be as part heard, my lord.
That is a difficulty. I don't know. I don't know. Ekele bohim. Why not? You are not standing yourself.
No, Lordship.
I had no objection, but since the matter has been.
No, because that day he said,
Yes, Lordship.
I'm going to Delhi. But still, we took a chance. That is not, that is a difference. Now, in the meantime, situation has changed. So there is some difficulty. And I do not want to pick it. I don't know where it is listed. If it is listed, then okay. Tuesday, we'll put it on Tuesday.
Mine.
Mr. P. Hazarika, Learned Counsel for the petition. First is present, MS
A Lodha.
A. Lord, Learned Counsel representing Mr. R. M. Das, Learned Spending Counsel, Water Resources State Department for the respondents has prayed for listing of the cases on so and so date. On the ground that Mr. Das, Learned Spending Counsel, Water Resources Department has gone out of the state on public ground. Release the cases on so and so dates. The interim order past release shall continue.
Mine.
Oblige your lordship.
Lordship, we have received instruction in this matter.
Instruction.
Right. We would like to file it.
Instruction.
Mine.
I need instruction.
No, we have received
Ah.
already.
You want file affidavit?
Mine.
Had Mr. M. U. Mondal and counsel for the petitioners. Mr. B. J. Talder and senior counsel assisted by MS. PDB. Learned counsel for the respondent number 1, 3, 4. 1. 3, 4, 5. And MSPR amount of Learned Standing Counsel Revenue Department for the respondent number 5. Mr. Talder has submitted that necessary instructions have been received to file the counter affidavit, and the counter affidavit will be filed within 3 weeks' time. He has thus sought for listing of the case after 3 weeks. List the case after 3 weeks for filing of counter affidavit on behalf of the respondents. The interim order past status will continue.
Oblige.
The next.
Items 42 and 55. May I please?
I would ask me 55. Lack of time.
Yes.
So many motions are listed today, it is difficult. I was, that is one, direct purchase.
Yes, yes.
Huh? Somebody else then. Affidavits are filed.
Yes, yes.
Yes, what do you propose?
But actually, in fact, we are willing to give. But only thing is they have asked us, they have given a letter to us that your land will be acquired under Assam Mara project, and you please come for negotiation. So accordingly, we went for negotiation with all our documents and sale deed. In fact, the price offered to us, we could not agree with that. Then we made a representation to the deputy commissioner, the then deputy commissioner, now district commissioner. But that is still lying, man. That is, they are not looking into those some
And they have
grievances.
filed affidavit. What they said?
They said that we will pay, in their affidavit, they are asking that the price that we have given, it is a correct price.
If a statement is made on affidavit,
yes,
in a writ petition, then no purpose regarding representation. They did not.
Very true, my lord. Our only grievance is that we must get some fair price.
Right. So you deny it. As simple as that.
In that event, they will.
We will not accept. Make it clear statement. Their entire process will come to a knot.
Very true, my lord.
Then they have to resort to
Exact-
213 Act.
Acquisition of the land.
Then you will get 5 times higher. But we'll be running out of time if we passed out. Yes, Mr. Tharuja, what do you say this? If both parties do not agree,
Then we'll have to resort to acquisition.
that is the scheme.
Fine.
And now Deputy Commissioner has made a statement on affidavit that we are not agreeable, we will offer this. And you
Well, then-
want a different amount.
Difference is very high.
High.
It's the price that is prevalent in this area, my lord.
Oh, that is not,
Otherwise, if acquisition also the market price has to be seen, that has been taken care of.
Yes.
that is not the function of the read court. That is what I am saying.
Yes, your lordship.
That is not the function of the read court. To settle a bargain.
Yes, yes. Very
This is
true.
only
Court
offer and
cannot
accept-
entertain to that bargain, my lord. Very true, my lord.
Offer and
Our,
Right.
we
It
are
has to
afraid
be
that-
offer and acceptance. If somebody does not accept, end of the matter. And we cannot say he is saying 5 lakh. You are asking
10 lakhs.
15 lakh say, and court will say 10 lakh. This is not the,
The court cannot sell it.
right? It is also not Lok Adalat
Yeah, exactly not.
and not a mediation process. It is a read process.
Well, our,
Heard, Mr. will differ. Not enough time to go through the provision and to dispose of. Because this kind of matters are coming up.
yes, the several matters are
Not
pending.
agreeable, both parties, liquidation.
They can, they should.
And the authorities also be sure about what they do. They cannot adopt forceful methods.
Well, this
Anyway.
is public project is being hampered. It is, they could not start the project.
If they are with this direct purchase method, everything will be stalled. If people are not agreeable, nothing will proceed.
Nobody can end.
Every development project will come to a standstill. And this particular scheme is not in conformity with 2013 Act. Yes, there is a provision. Yes, direct purchase, offer and acceptance, agreeable, end of the matter. There is also provision like this in other act. GMD Act, it is there. GMD Act, it is there. I haven't seen that. Heard Mr. S.C. Viswas and Counsel for the petition and Mr. B.J. Talgar and Senior Counsel. Assisted by students or for personnel for the state respondent and MSPR Mohanto, Standing Counsel Revenue Department. Post of short for by the line of the part of parties. List the cases. List with a They were together earlier, right?
Yes, yes,
Got separated.
yes.
That is the bit. After a week,
Hello. Diploma.
May it please your lordship.
yes.
Lordship, I am appearing on behalf of Miss Arbora. She is unwell and she has to leave the court, Lord.
Unwell, okay.
Lordship. Kindly next week, Lordship.
And a short date next week then.
Unwell. What is the case here?
Well, it was about the expiry of a tenure of a market regulatory committee. And the Honorable Court had on the last occasion on 22/4/2024 directed the pending council to file an affidavit
Oh.
setting the timeline in which the election would be held.
Okay.
They filed it, my lord, but it's very vague. So I'll have certain submissions to make.
Mr. Borua, you are otherwise as an ex-chairman, you are in a slippery ground.
My lord, I'll have to make some submissions on that based on what they have submitted in the affidavits.
Okay. Mr. A. Borua, Learned Counsel for the petitioner, and Miss
Z Bora, Lordship.
G. Borua, Learned Counsel representing
Arbora, Miss.
MS Arbora, who is he? Standing Council,
Lordship, standing on the Agriculture Department.
Assam Agriculture.
I am for respondent 4 and 6. Arbora for respondent.
Assam
State Agriculture Marketing Board.
State. You are for 4 and 5.
I am for 4.
He is for agriculture or what?
Lordship,
He is for
Agriculture.
Okay, agriculture department. For the respondent number 1, 2, and 3, and Mr. NJ Guru. So, standing council. Assam
Some State Agriculture Marketing.
Agricultural Marketing Board. For the respondent number 4 and 5.
4 and 6.
4
4
and
and 6.
Okay, agriculture is 1, 2, 3, and 5.
Yes, to the 1.
She is also for 5.
1, 2, 3, and 5 Lordship.
Okay. MS Bora has submitted that MS G Bora has submitted that MS R Bora, Land Standing Council, Agriculture Department is in this post and has thus paid for listing of the case after a week. The finger of the ground cited. The price accepted. Therefore, adjournment is accepted, is the case.
My lord, can it be on 22nd if it pleases, my lord?
Later, someday later.
On a fixed date, my lord. I have no objection.
3-6.
Budget place.
Item 44.
My lord, here in the case, we have received affidavit opposition, my lord. I like to reply that one.
Mr. J.I. Borvian, Land Council, the petitioner has paid for and is granted
3 weeks time.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed on behalf of the state respondents. Mr. P.J. Taludar, Land Senior Counsel, estate by so and so. P. Devi, Land Counsel for the state respondents is in attendance. Please the case of it.
Item number 54.
Yeah, please, your lordship. Lordship, mediation report.
Mediation?
Sent for mediation. Mediation report supposed to have.
Failed. Failed.
Yes, Lordship. I am on behalf of the respondent number 1 to 6, Lordship's LICI.
Number 6, 7 and 8.
Hard, mister. Notice has already been issued. Hard, mister.
R. Besburwa.
R.
Besburwa.
Besburwa. Learned Counsel for the petitioner. A.L. Mondal, Learned Standing Counsel.
Yes, LICI.
Life Insurance Corporation of India, LICI, for the respondent number 1 to 6, and Mr. B.B. Sharma. B.P. Sharma, Learned Counsel for the respondent number 7 and 8. So stop. As per the report of the mediator, the process of report of mediator dated 15/5/2024. Comment. The process of mediation has failed. Full stop. An affidavit in opposition on behalf of the respondent number 1 to 6 has already been filed. Full stop. The respondent number 7 and 8 are yet to file their counter affidavit. So, any time. Okay, Mr. So-and-so, Learned Counsel appearing for the respondent number 7 and 8 has paid for and is granted 3 weeks time to file affidavit, counter affidavit on behalf of the said counter affidavit. Full stop. The interim order passed early on 10/3/2023. Oh, it is already there till disposal of the report. Yes. Already there till disposal of the repetition. Please the case after 3 weeks.
Item 47 for orders.
Blood service report upon respondent number 7 is awaited.
Awaited.
Yeah.
All the okay. Mr. M.E. Mondal and Council petitioner and M.S. Porua. Last Junior Government Some for the respondent number 1, 2, 3, 4, 5 are present in view of office note dated 24/4/2024, comma, await for the service report in respect of the respondent number 7. Post of raise the case after 2 weeks.
Interim order. Interim order.
It is there. Yes. It is like that. It is tricky. Well, however, this court is not inclined to grant the interim order as paid for. Nonetheless, it is directed that any allotment made has to be preceded by a recognized procedure established by law. So it cannot be extended. Yes. It is very tricky.